Okay. It's a huge pleasure to welcome you here to this very historic setting. I'm Danny Pruskel, the senior partner of a telecoms and technology specialist law firm, Pruskel & Co., which is a Band 1 ranked chambers firm for telecoms, data protection, cyber security, and most importantly, we are the Lexing UK member firm. So what I'm going to do is set out a quick introduction. We are running a bit late. There's a lot of people from across the world on the YouTube channel, would you believe, which has been set up by the French law firm Alain Bensoussan. Now, as many of you appreciate, AI is a challenge to the legal profession in a number of ways. First of all, we have to work out how to regulate it, which is much of the theme of today's conference. The second element is actually the challenge it poses to the legal profession in terms of jobs as well. We've seen some pretty depressing statistics about the amount of jobs, legal jobs that will be lost to AI, and I think to an extent we'll have to see how we deal with it, and I think as lawyers we will always need to work out how we'll be ahead and providing a service which is better than the AI. But on that slightly negative note, I think we should take some inspiration from the setting, the historical setting in which we are located. If you were to look out, actually there's no window there, but if you did look out there, and we'll go on the break, there's the Temple Church. Now, the Temple Church in the 1100s was the home of the Knights Templars, famously depicted in the Da Vinci Code, and it was actually also filmed in that church. And they were the head of the Knights Templars for the whole of Europe and the Middle East. And eventually, over about a couple of hundred years, it got taken over by the lawyers. And this area, since the 1300s, has been really the home of leading barristers, the ones who litigate, and judges. And with English and UK constitutional law, a lot of it is common law, which is the decisions of judges. So if you think from the 1300s, we've had incredible legal challenges that they've dealt with and overcome. And in fact, the Magna Carta, which is in some ways the basis of the UK constitutional law, was as a result of what happened in the Temple Church just there when King John had to negotiate rights under the Magna Carta to be released. So this place is really the founding place of the British Constitution, although albeit it is unwritten. And then, so for hundreds of years, law that had to deal with all the various challenges. One challenge dealt here in relatively recent history in 1766 was the Constitution of the United States, and that was actually drafted by quite a number of lawyers based here. So that's kind of more recent constitutional law. And as I say, the law is always developing in these buildings, this area. And let's hope that they've overcome so many challenges over many hundreds of years, and I think that should all give us inspiration. This AI, when we see it as a threat and a challenge, is something that we will deal with and master. But we are very much at the outset of AI regulation, and that's why you're all here, and those of you online, there's many of you online as well. So in terms of what we've got for you, and we can talk a little bit more about the history going forward and the inspirational for that, but most importantly, we've got top lawyers from across the world, which is the beauty of the Lexing network, where we have really leading emerging technology lawyers who can really give us insight and give for clients a sort of global overview of the challenges and how to overcome them. And I'm very pleased to say that many have travelled from across the world, and in particular I want to thank Dudley Nella, who's travelled from Australia, and that's actually near compared to David Alizada, who's come over from New Zealand to show us the link from very far down under. But the effects of the European EU AI Act in particular will be felt across the globe, whether people like it or not. As we've seen with the GDPR, that's had huge impact across the globe, and we expect that the EU AI Act will do as well. So in terms of, just to give you an outline of the agenda today, we'll have an introduction from Frédéric Foster from Alain Bensoussan in France, and then Jérémy will really set out the scope of the AI Act, and then we'll look at enforcement and compliance, specific sector impacts, and then in the UK, thanks to Brexit, we're kind of showing our own path, so we'll have some input from the Président UK team about how the UK approach is slightly different to the EU, for better or for worse. And then we'll look at extraterritorial reach, and then also look at some of the litigation element. There's a lot of litigation in the pipeline and already underway in terms of AI. And then we'll be looking at next developments and how we all prepare in terms of companies for dealing with the impact of AI and make sure that we can de-risk exposure to AI regulation and the impact both commercially as well as from the legal perspective. In terms of a little bit more about the Lexing network, it was created about 15 years ago, the brainchild of Alain Bensoussan, who's here, leading a French technology law firm and real visionary. I think about 15 years ago, he had us drafting the first international comparative book on robot law and writing about drones before people were being really killed by them on a mass scale. And you have to deal with it. You have to deal with the privacy aspects. I've been advising drones companies, Africa, thankfully delivering aid rather than explosives. So, but that is really the vision we had. Also, thanks to him, I met my first robot in a law office environment, and more recently, thanks to the network, I've been hosting meetings in our Lexing metaverse office. And one of the beauties of the Lexing metaverse office is that my avatar is far, far younger and far cooler than me. So it's always a bit depressing when I have to come back and be in real life. And one of our clients who's very proudly producing real life avatars, I say, no. I like the ones that have a maximum age of 25 years. But we like to think ahead, be ahead of the curve. And now really is the time to discuss AI and its implications, both, as I said, for the legal profession as a whole and how we deal with it in terms of advising clients and the legal challenges. So we've had a bit of a late start because of the connection to the YouTube channel. I think there's over 1,000 people listening from across the world. So I'll curtail my intro and hand over to the first of many experts that you'll be hearing from today. And I think we'll start with Frédéric Foster from Alain Bensoussan. Thank you.
Thank you, Danny. I'm very happy to be here. I'm Frédéric Foster, just like Danny said. I'm a lawyer at Lexing Paris, so I'm belonging to the law firm that has founded this Lexing network. And we are working together with Danny within this network we've been working for 14, 15 years now. You were one of the first law firms of this network, and we are very proud and very happy to be here. Yes, I will make a very short introduction to the EU AI Act and give you perhaps some clues to understand what's behind this act. And I hope that I will have access. This was the agenda. This is me. Well, this is my history, where I come from, etc. It has no real interest. the Lexing network has been introduced to you by Danny. So perhaps just one or two few more words. We are now represented in 45 countries. So we are covering a fourth of all the countries in the world, which is a very good achievement, I think, for a network that has been founded just 14 years ago. And as Danny said, we are all lawyers specialized in new technologies, and we are able to cover all the needs that you might have in that field. And here is the map representing the countries where we are today, and one country is missing, which is Denmark. Denmark has just joined us last week. You recognize your country? Yes, we are in India, yes. So just this short introduction to the EU AI Act with some clues that you have here. What's the situation? Well, there are lots of things to say, of course, concerning this EU AI Act, but perhaps the first issue I wanted to stress is that it is a regulation that is aimed to introduce a trustworthy AI. And trustworthy AI is everything that is in fact a precondition for the deployment of AI systems on the European market. We are shifting from, in fact, an innovation-driven regulation to a regulated trust. And this shift from an innovation-driven market to a market driven by trust comes from other EU regulations where you can find this idea that thinks that products must be safe, that concerning AI, it must be explainable, that you are accountable for what you are doing, etc., etc. So these are things that you find in the EU AI Act everywhere. And when you look at all the articles, you will find some elements and some clauses or provisions that are directly linked with this condition: AI must be trustful. The challenge is that it is an horizontal regulation, meaning that it's a regulation that applies to all sectors, to all kinds of products, to all activities. So you have to combine sectoral regulations. You have regulations, for example, for transportation. You have regulations for other kinds of activities, which are vertical regulations. And you have to combine that with this horizontal regulation concerning AI. So you have lots of points of contacts between those regulations, which makes everything very difficult, to be honest, to apply. And being compliant with the EU AI Act is something which is really, really very difficult, to be honest. The news, generative AI, it's not really a news, but what is new is the way that Gen AI has developed. More than billions of people are now using Gen AIs. It didn't exist 3 years ago. So this is something totally unexpected. And it was unexpected at the time the EU AI Act was discussed. And at the end of the discussion of the EU AI Act, generative AI had to be regulated. The regulator didn't think that this should be something that should to be regulated. And you find now special provisions in the EU AI Act concerning generative AI. But those regulations came at the end of the discussion of the regulation. And the trend is the development of intellectual robotics. We will never work in the future like we worked in the past. AI is everywhere. AI will help us, and I think that during this day you will understand how it will help us, we as lawyers, how it will help us in our everyday work. And the major work or the major word that you should have in mind is either cobotics or robotics. AI will create that new world using robotics. Perhaps some quantitative view, and figures concerning the EU AI Act, 180 recitals. So you see the regulator had lots of things to explain because honestly, it's a very difficult text. I see some people that I know. I see Laetitia. I don't know if you had the opportunity to read the EU AI Act, but it's something that is really very difficult to understand. 113 articles, 13 annexes, 68 definitions, and everything is in the definitions. You have to understand the definitions, otherwise you will not understand the Act. 3 main technical objects. They will be introduced to you by Jeremy and Mark probably. 5 levels of risks. AI systems are divided in 5 categories, and each of those categories are representing a risk, and each of these risks is regulated by the Act, and everything is built on pillars, 2 main pillars, 6 values, 3 values per pillar, and I think that Jeremy will introduce you to those values. It's a it's a product-oriented regulation, and it's not a fundamental principles-oriented regulation. It's the difference, for example, between the EU AI Act and GDPR. GDPR, you have principles. In the EU AI Act, you have a regulation that is typically a product-oriented regulation. The timeline for the introduction, it has been adopted on June 2024. It entered into force on August 2024. Some of the provisions of the 5 first articles of the EU AI Act entered into force on February 2025, only the 5 first. Last August, some other provisions entered into force. The main entering into force of the EU AI Act will be in August 2027. So it's not today, it's not tomorrow, it's in 2 years. This time is, what's behind this timeline is to give an occasion for all of those who are concerned to be compliant by August 2027. As I said, it's an horizontal regulation that crosses all the vertical regulations that you can find, which is the case for other regulations. We had a project in the EU about the liability directive, but it has been abandoned. So this is why you see stop. It's the case for the personal data regulation as well. It's the case for other regulations. I just took some examples here, the machinery directive or the product liability directive, but there are much more other regulations that are horizontal. It's not typically the case for the EU Act to be horizontal. Well, those are the few things that I wanted to share with you, and now we will enter deeper in details with Jeremy. Please, Jeremy, it's your turn.
So, hello to everyone. I'm Jeremy Bensoussan, partner at Lexing in Paris, head of the AI law practice at the firm, and I'm very happy to be with you here and online, of course. For my presentation, I would like to underline 6 key points. Which are the following. First of all, so the first one will be to adopt a compliance posture. Second of all, we need to understand your position within the AI Act. Third will be to qualify the AI system you're dealing with. Then determine its level of risks. Then after that, qualify yourself or your partner in relation with the AI system we're talking about and its level of risk. and lastly, follow the road to compliance. So first thing, what do Boris Johnson and Kim Kardashian have in common? So it's obvious. It is their use of AI, of course. For the first one, he's been using AI to was not that happy about it at the end. So with those numbers, I'm sure that you are concerned, but to get more deeper, 700 million individuals are using ChatGPT each week. 40% of jobs are exposed to AI impact. 78% of organizations are using AI. So those are very massive numbers. And so I'm sure these numbers resonate with you. But the question is, are you in a compliance-ready position? And that is what we want to make sure today with all of our presentation. So about the timeline, what is already applicable up to date? So Article 4, for example, on AI literacy is in force, meaning that we, as an organization, need to make sure that we receive sufficient training in AI, that we understand sufficiently how it works and what is at stake. Also, Article 5 on prohibited practices is in effect, and we will get more deeper about those banishment. And also Article 51 to 56 on general purpose AI models those articles are in effect. And so there is where we are, and what is coming next. So high-risk AI system regulation is coming August 2nd, 2026, and the rest of the regulation at that date, except taxation. And for high-risk AI system through Annex 1, we'll be dealing with up to August 2nd, 2027. So next thing, which is from my perception very, very important, is to understand your position within the AI Act, and to make sure that we can make that happen. We need to deal with three main points, three questions. So first of all, when you consider a specific AI system, we need to make sure that it corresponds with the definition the AI Act gives. Then, when this qualification has been made, we need to make sure that we determine the right level of risk associated to that AI system and its use. And third, you need to make sure that you identify your role in relation to this AI system. Do you just use it? Do you sell it? Do you import it, etc.? So AI Act, it's a highly complex regulation, and just one comment about that. The European Commission will soon simplify it through its omnibus digital package. But right now, we need to address it in its whole complexity. So first of all, how to qualify the AI system we are dealing with. So the definition is in Article 3.1 of the AI Act, but what we have already is some guidelines from the European Commission from July 2027, and seven criteria have been underlined by the Commission. Two of those 7 criteria are more important, which are on the one side autonomy of the AI system, and on the other side the inference capacity of the system. Why? Because the inference capacity is the source of the autonomy. And what we know from the state of the art is that inference produced by a probabilistic models generates autonomy. And that is why when you can make sure that some technology are used, then you're sure that this software or this system is an AI system. And for example, when you get more into the technology level, if you know that technology of transformers is used, so you know that it is an AI system in relation with the definition. And to make sure of that, something very very simple to remember, because ChatGPT is for generated pre-trained transformers, and so you have here a direct link between the name of the state of the art and the fact that it is an AI system. Also, when the system used recurrent neural networks, you are quite sure that it is an AI system in relation with the definition. And then this approach make possible to map your information system and to divide it into two. On the left side, for example, what is only traditional IT, and on the other side, what is artificial intelligence IT. And you can make sure of that if you can pinpoint the technology that are used in those systems. So second, about the risk level, and we'll get more deeper in that during the day. But let's assume that the AI system we're talking about does not fall under the unacceptable risk, because then you have some banishment. But if we are not talking about those banishment, you have 5 level of risk. 3 of them are about AI system, and 2 of them are about general purpose AI model. Then and finally, so you need to qualify yourself in relation with the particular AI system and the level of risk. Different actors are defined by the regulation, and of course, provider and deployer are the main 2 qualification. And so that is the most important things to do, to make sure to know where you are, where you stand within the AI Act. And when you have done all that, you can follow the road to compliance. So first of all, of course, every AI initiative should begin with a clearly defined use case or use cases, following by assessing its return on investment, and then make sure that it is successfully adopted. Organization must map all AI tools in use and phase out those that are banished. Also, governance is a key aspect with clear missions. That is very important. Updating the IT policy is something that needs to be done as soon as possible, if it's not already done. We talk about AI literacy, so making sure that all of your personnel is being trained to use AI in a convenient way. And last thing maybe, so to secure your AI acquisition and commercialization, adopt a contractual framework combined between mandatory clauses on the first side and also recommended clauses. And so with this conference, we're here to guide you on the road to compliance. And Marc Gallardo from Lexing, Spain, and now the floor is yours. Thank you very much.
Good morning, everyone. Well, let's continue with this EU AI Act, which I think that it has been already said, it's a very complex piece of legislation. So I think we have quite a consensus on this. But I will elaborate a little bit more so you understand why we are saying this. This is also why you need good assistance, and lawyers from the Lexing network can provide you, of course, with this legal assistance that you will need for sure. Because first thing that should be said is that this very important piece of legislation has an extraterritorial effect. What does this mean? It means that it's not only a piece of legislation that applies to EU-based companies, but also UK entities or entities from other jurisdictions, to the extent that they place on the market, on the EU market, or put into service on the EU market AI systems. So it's not something that you should look as, well, maybe this is interesting, we can maybe follow some of these rules, because as Frederic said from the outline, from the outset, this helps the use of AI in a trustworthy environment, but it's more than that, actually. So you can be captured, and your AI use or developing AI can be captured by the EU AI Act. So it is very important that you understand this extraterritorial effect. So the fundamental logic that is behind the EU AI Act is what we call the risk-based approach. So this means that basically, as it has already been summarized by Frederic and by Jeremy, the Act classifies AI systems depending or according to the risk. To the risk what? To the risk for, or for what? To the risk for the fundamental rights of individuals, health, security, and also democracy and the rule of law. So these are the risks that the Commission, when it first issued the proposal in April 2021, was thinking. And this is a flexible framework. It means that it could change, right? Because another key idea of this Act is that it does not regulate the technology per se. Because, you know, AI is not a single technology, it's a bunch of technologies, but it's not wise to try to regulate the technology itself, because it depends on the use, right? So at the end, what is being regulated by the Act is the use of AI, in which context you are using AI. So depending on these use cases, then the Commission, and finally with the UA Parliament and the Council, they decided, as you will see just in a moment, these different use cases that are deemed unacceptable or high risk or limited risk. So classification matters, and Jeremy, you pointed out something which is very important. Before classifying AI systems, which is something very important you must do in your organizations, you must ask yourself if you are using an AI system, because as Jeremy pointed out, there is a definition. So maybe you are using traditional software, but not an AI system. So first of all, you have to understand what you are using within your organization. But assuming that you are using an AI system, or you are developing an AI system, depending if you are a provider or a deployer, right? Then the second thing, most important thing you have to do is to classify adequately the AI system. Because misclassifying the system can have two basic risks. One is over-regulating. So you are, placing yourself too much burdens that you are not obliged to comply with. You can also create for yourself a competitive disadvantage, right? And of course costs, because if you have to adapt to the requirements of a high-risk AI system, for instance, it's costly. I mean, you have to allocate a significant budget, right? It's not something that you can do just in a week and with a very low budget. So it's very important not to over compliance, but also not to under compliance. Because if you misclassify your AI system and you think that you are in a limited risk AI system, but turns out that it's a high risk AI system, then probably most likely you won't have the appropriate safeguards. So this creates important risk from the regulatory point of view and enforcement, of course. Let me tell you one thing, and I think that this maybe be developed by any of my colleagues afterwards, but enforcement nowadays is not possible. It's not possible. Maybe for Italy it is, but you know that there is a gradual application of the AI Act. You've seen that there are different timelines, etc. But in 2 August this year, the different member states should have appointed the supervisory authorities in charge of this enforcement, but also the sanctioning regime in their own internal laws implementing the AI Act. But this has not been done so far. They have all except Italy delayed this. So there is a very curious situation, which is that you have provisions that are already in theory enforceable, but you have no supervisory authority that is able to impose such sanctions. Well, this is, I mean, something that will be solved in maybe the next months to come, but I mean, it's a very curious situation because there was a hurry, you know, in adopting this AI Act. There was a lot of pressure. The EU Parliament and the Commission was about to change their mandate, so they really needed to send a message to the EU citizens saying, look, we take care of you, and here is the result of our hard work. But this led to a very complex piece of legislation. And now also there is a very big geopolitical tension. You have the Trump administration saying, because of this extraterritorial effect that I was mentioning 2 minutes ago, they're saying, look, we cannot accept that the US companies that sell AI in the European Union market have to abide to these complex rules because this creates a disadvantage compared to the Chinese that are number ones in this career. So this is a problem, and also there is this Draghi report saying, look, we have to simplify the act because it places a lot of burdens to the EU companies or the companies that are selling AI within the EU. So there are a lot of now changes that are coming on. So stay tuned, because what we are saying here can change in very few time. And this is something that you can realize how complex regulating AI use cases can be. But well, at the end, just to pass the message here, the key principle of the EU AI Act is the higher the risk, then the more stringent the requirements are, right? This is something logical. And this is what is behind all this EU AI Act. And this is the famous risk pyramid that you will see always when referring to the structure of the EU AI Act. So you see at the top of the pyramid the unacceptable risk. These are the use of AI or the practices involving AI systems that are unacceptable. Why unacceptable? Because they are at odds with the fundamental rights, with the values of the European Union, and may create or pose a danger to the society. You will see, I will enumerate them or describe them just after. Then you have high risk, which I also explain when your AI system can fall into this category. You have transparency risks, and then you have minimal risk. Just for you to let you know that the one which is in the base of the pyramid, so the minimal risk, is not captured by the EU AI Act. Means that if you analyze your AI system and you analyze if it's an acceptable risk, the answer is no. Then you go and see if it's a high risk, you say no. And then you see if it's a limited risk or not AI system, and the answer is no again, then you fall into the blue category, and this means the AI Act does not apply to that AI system. And let me give you a very important figure here. The Commission itself said that 85% of the AI systems fall into this category. So what we are saying at the end is most of the AI systems that you are going to use will fall into this blue category, minimal risk, which is not captured by the EU AI Act. But does this mean that it's the Far West and this AI system does need to comply with any requirements? No, because there is this famous interplay, a very complex interplay between the EU AI Act and the General Data Protection Regulation, consumer protection, cybersecurity, etc., etc., etc. So still, as a law firm, for instance, or another type of organization, you must govern the use of AI, because the use of AI is associated always with risks. So you have to handle these risks. So as Jeremy explained before, you need to prepare, plan a roadmap to try to minimize such risks. So even though you are not captured by the EU AI Act, because it falls under the blue category, minimal risk, still you have to deal with it and you have to govern it, because you don't want to create materialized risks on data protection or whatever other applicable rules that this use of the AI system oblige you to comply with. And then do not forget that, as Frederick said before, when the act was being negotiated, then OpenAI offered the world ChatGPT in November 2022. So they had to introduce a new chapter, chapter 5, of the general purpose AI models. So here we have transparency requirements, most of all that the providers have to comply with. So documentation, also copyright policies, and also they have to fulfill a template where they explain what data, what contents they are using to train the models. And the presumption that you are a provider of general purpose AI model is linked to something very technical that I'm not able to explain to you if you have the question afterwards, which is the floating points, right? So which means the computing power that is required to train the model. So if you have 23 flops required for this model to be trained, then the presumption is that there is a general AI model, so you have to abide by these rules. And also the systemic general purpose AI systems, which are the ones that really can produce very adverse negative effects to individuals or the society as a whole. So imagine, for instance, ChatGPT. Then the presumption is if it's 1025 floating points, then it's a general purpose AI model with systemic risk. So you see, wow, this is really very complicated, but it's a threshold in order to determine if or not there is a general purpose AI model captured by the AI Act, and also if it's a general purpose AI model with systemic risk. So this is the basic pyramid. And then which are the AI's uses or practices that are forbidden, that are banned so far today? These are the 8 different cases of prohibited practices that you will find in Article 5 of the EU AI Act. And probably, well, the thing here, just to cut it very short because I'm running out of time, is that in these categories, you have some of them that are absolute, so no exceptions apply. Means that if you fall into one of these, you should not continue developing the micro. I don't see it. Sorry, yes, I see it now. Sorry, I tend to move always, and I forgot that the micro is here. Sorry for the people that is connected remotely. Well, what I was saying is that you have some prohibited practice that admit no exception here, but there are others that may admit exceptions. So just for you to give you a sense of how complicated this is, the Commission issued guidelines about these 8 cases of 150 pages, more than the Act itself. 150 pages. That gives you a sense of how complicated it is to interpret whether or not you fall into a prohibited practice, which means that many times one of these prohibited practices will turn into a high-risk AI system, because if it doesn't meet all the conditions required to be considered as a prohibited practice, most likely this AI system will be classified as a high-risk AI system. And of course, this is in force since 2 February this year, but the problem is that it's not enforceable. In Spain, where I live, even if you are now performing a prohibited practice, no one can sanction you. But this will change, of course. But you know, in Spain, until we don't see the danger, we don't react. I don't know in other countries, but generally speaking, in Spain it's like this. Then understanding high risk. So there is a two pathway or twofold roads that can lead the AI system to be classified as a AI high risk system. One is when AI is a safety component or a product itself covered by the EU harmonization legislation, which is Annex 1 of the Act. And you can see here on the right a list of products. So, for instance, medical devices, toys, lifts, the ones you see here. If the AI is a safety component or the product itself of such products listed in Annex 1, then it's a high-risk AI system. And then you have Annex 3, which describes, again, 8 different areas. So remember, prohibited practices, there are 8, and Annex 3 covers 8 different areas. And in each area, the Annex 3 describe which is the case use that is considered a high-risk AI system. So you just have to check whether or not your AI system, the way you are using it, falls or not into any of these descriptions on each of these areas. Probably biometric and employment is or are the ones most probably applicable to any organization, apart from if you, for instance, are on the financial services area, then also you can be captured by the essential private services area. So it's something that you have to check, and again, Lexing members can help you do that. And then finally, limited risk AI. So this deals with the transparency obligations. So if you are deploying a chatbot, for instance, or you are creating a deepfake, so you are altering the reality, right? And you are creating an appearance that something is real or authentic when it is not, then you have to be transparent. You have to inform people that this is something that has been created or manipulated by an AI system, okay? And also for providers of Gen AI, for instance, they have the obligation to mark the content that is AI generated. And this is something that probably will be simplified by the Omnibus regulation, because they are thinking of postponing 1 year the obligation that in principle will be applicable on 2 August next year. So we will see how these transparency requirements, again, just for you to recall, will be applicable on 2 August next year. And finally, minimal risk. As I said, these ones falls out the application of the EU AI Act. My last slide. Key takeaways, well, you have to plan. You have to plan, and if you haven't done it, you must do it right now. So you must perform this assessment first. You must understand whether or not you are using AI systems in your organization. Probably the answer is yes, we are using it. I hope it is not shadow AI and that you control it and you identify it. This is what you have to do, the next step. So plan, identify, and then assess, classify in which risk. If it's not captured by the EU AI Act, then also don't forget you have to govern such AI use. And also think that you need investment. So this is why you have to prepare in advance, because it's not easy to comply with all the requirements. Most of the requirements are on high-risk AI systems. And the problem is that the standardization that should be already have approved is not. So there are different SEN, SENELEC, different bodies that are working on that. But it's very important that we have this standardization approved, because once we have it, if an organization abides by these technical rules, then there is a presumption. There is a presumption that is compliant, this organization, with the rules of the high-risk AI system. So it's very important to have this, but we don't have it yet. And we don't know when we will have it. So, I mean, you have to plan well in advance. And remember always, transparency is king, is a must. And if you are transparent, you create trust. And if you create trust, you create adoption. So I think it's important to keep this in mind. And this is pretty much what I wanted to say. Thank you for your attention.
Mark, thank you very much for that. And Jeremy, we've got time for perhaps one question before we break for coffee. But again, just want to say thank you for helping us decipher through the complexity of this almost, I say, monstrosity in terms of just volume and complexity, rather than, I think, what are actually very sound underlying principles. So I personally found those two talks hugely helpful. So we'll take one question before, and then say Mark and Jeremy and all of us will be around during coffee and lunch breaks and further forward. But we have one question at the back from Dudley, our Lexing, Australia lawyer.
Thanks, Danny, and thanks for the presentations this morning. What's the impact for organisations if they get this wrong?
Well, I think Mark was saying in Spain, we shall see that, but I'll pass it over to Mark.
Yeah, 35 million euros or 7% of the annual turnover of the company as a maximum, and the higher of the two. Well, this is the quick answer, but I mean, it's something that you don't have to take for granted, because sanctions are very significant.
Thank you, Mark. Yeah, that's a very important headline figure to bear in mind. So hugely important. And actually, on the GDPR side, we've seen some incredibly high sanctions in the billions of euros. So something to certainly bear in mind going forwards. So I think with that in mind, we'll take a short 15-minute break, and then at 11 o'clock, we will resume on the subject of enforcement and compliance. Thank you. Thanks. Well, Javier is actually one of the Preston & Co lawyers in our commercial team and film and TV department, and he is Mexican, but we have a very, very international team in our London office. Our London office is just literally there, and whilst he's a Mexican based in our Preston & Co Lexing UK London office, the Lexing UK lawyer and member firm for Mexico is none other than Enrique Ochoa, and we're very, very pleased to have Enrique come and talk to us about AI regulation enforcement, and from an international perspective as well. So over to you, Enrique. Thank you very much for coming all the way from Mexico to share your experience with us. Thank you.
Thank you, Danny. Thanks for having us. Hello, everybody. I'm Enrique Ochoa, and I'm the managing partner for Lexing Mexico. And we're I have Ruben, my partner, also, he's in the back. And we're very pleased to be here with you and explain a little bit of this AI regulation. From our perspective, this is very interesting because this is obviously a European law, and it has extraterritorial effects in all the countries in the world. And for us, for this type of regulation, at some point makes an obligation for us. I was just discussing with Lexing members that probably we will need to amend our engagement letters if we are rendering services to European clients. We will need to disclose that we are using artificial intelligence, and it would obviously depend on the risk or minimum or high risk of the information we will be using and the data we will be obtaining. But at the end of the day, I think that in order to play safe, we will need to amend these engagement letters for European clients disclosing that we're using AI, or we will be using AI, which AI will the law firm will be using. And obviously the training obligation for these organizations will have to take place in other countries, in Mexico, for instance, and all these European, non-European organizations. And before getting into the law, I just wanted to tell you that we just had a criterion from our Supreme Court, which is very different from other perspectives in other countries. And for a Supreme Court, it's just one criteria. It's not that it's a mandatory provision, but for our court, a work created via artificial intelligence is not subject to copyright law. Not even that. It's a public domain work, so anyone can use it. And it was a case that it was invented by a lawyer. This lawyer created something with artificial intelligence. I don't remember which one. He tried to register before the Copyright Office, and the Copyright Office said that since it was not created by a human, it could not have that copyright protection. Remember that we take not the copyright from England or the US. We take it from the French legislation, from the French point of view. So the thing is, if you create something in Mexico and you want to register, it cannot be protected. Therefore, you will have to protect it somehow different, probably a trademark. I don't know. But at the end of the day, what I'm starting to say is, it's going to be very difficult to have this type of legislations because the points of view of different countries obviously are differ. And I don't know what we're going to do. I don't see Mexico having an artificial intelligence legislation in the following years, but at the end of the day, we will have to comply with this legislation if we want it or not. And for instance, we also represent advertising agencies in Mexico. So that's what I was referring to, this criterion from the Supreme Court is, if these advertising agencies create in generative AI, for instance, a character or something, this won't have any protection. So it's going to be very difficult to enforce creations derived from generative AI. What I wanted, because of some of my slides, they have already talked about it. So I'm just going to try to make reference to the obligations of the providers. As mentioned by Mark and by previous speakers, these are the obligations of the providers. They will have to ensure compliance for high-risk systems, implement a robust quality management system, conduct required conformity. And this is pretty much for providers, and these providers obviously are these companies that have developed and have created this artificial intelligence. But I think, as mentioned before, is for the deployers. The deployers we are the ones that are using the artificial intelligence, and we're using it not only for our purposes, but for purposes of third parties. So, as mentioned before also, we will have to assess which type of artificial intelligence are we using, what are we using it for, and obviously there would be, in the following years to come, new AI systems. And another interesting thing, the scope of the law refers to artificial intelligence as a product, not as a software only. And therefore, in our perspective, we will have to comply. We have a similar thing in Mexico. We have a consumer law, we have an advertising law, and we have liability, and we will need to comply on the results that we will gather from the artificial intelligence in order to render our services, mainly for lawyers. This is the pyramid that Marco already talked about, the minimal and the unacceptable and minimal risk. Jan is going to talk about the penalty, so I will just draft it. And my last commentary would be, my concern is that this law does not limit as such what would be the artificial intelligence, the information that gathers from us. For instance, if I ask the artificial intelligence saying, please act like a Mexican lawyer and draft an agreement for an oil company in Mexico, the artificial intelligence would know immediately which company is, because in Mexico we only have one oil company, which is called Pemex. So artificial intelligence at some point is going to know probably who our clients are, even if we don't disclose it. And what are we using it for? And that's a little bit of my concern. And it's not that I'm saying that it would turn into Skynet and have this Terminator thing, but at the end of the day, what worries me a lot is that these type of laws do not control what the artificial intelligence could end up being. And this is, they will have information on who you are, what you do, which are your clients, and what you do for your clients. And that worries me a lot on privacy matters. Yeah, thanks very much.
Okay, our next speaker, on the microphone here, is Alain from Lexing, Finland, who's going to talk to us a little bit more about penalty.
Thank you very much. My name is Jan Impari from Attorneys at Law Trust, and great to be here. I thought about starting with some kind of smart joke about English veteran umbrella as a risk management tool, but just looking outside and us having our first snow in Finland, so I think I just go directly to the topic, so you are so much better off here. So we walk through the penalties under the EU AI Act, and more importantly, what organizations can do to reduce the exposure. And we also talk about situations where all these different acts in the EU's digital framework actually collide. And these are pretty much the topics of the next 10 minutes. This has mostly been already discussed, but a bit of a context. So from penalties point of view, enforcement will be handled by national market surveillance authorities, European data protection supervisory for EU institutions, and Commission's AI office. as well. So there is not a one super regulator, but a network of regulators with different backgrounds, including data protection and product safety. So that has to be taken into account when thinking about penalties. Regarding timing, as it has been already mentioned by Jeremy and Mark, the act already entered into force, and regarding penalty provisions, those actually already kicked in August of this year. So the headline is simple: even though some of the obligations land later, the penalties land early. So if you wait for your system to be formally classified as high risk before doing anything, you are already too late. And then about the penalty framework and any lawyer's favorite topic, money, that has already been discussed today. This actually, it's a kind of penalty framework that is not shy about sanctions. So maximum fines can reach up to 7% of global annual turnover, as has been discussed already, and it's even higher than the top GDPR bracket. There are different types of ceilings for different actors, and member states will still have some are able to define their own national ranges within those caps. And here we have the diagram, and I can briefly explain that. So the arrows in the image show the hierarchical and sequential layering. So the general penalties by national market surveillance authorities in Article 99, special regime for EU Union officials in Article 100, and then in Article 101, there is the GPAI providers provision, which is overseen by the Commission, and you can see the sanction levels there from the picture. And what is important to keep in mind is that these apply across the value chain, so the providers, importers, distributors, and deployers. So even if you only integrate or use someone else's model, you can have your own independent exposure under the Act. And what comes to the enforcement logic of these penalties, they are familiar from DSA and GDPR, so they must be effective, proportionate, and dissuasive. And if you have a problem, so authorities will focus on gravity and duration of the infringement, whether it was intentional or negligence, and like in director's liability cases, how quickly you took actually remedial actions and how cooperative you were. And as said, it's the global turnover, so undertaken is understood in the same way as in the EU competition law, so it's the global turnover, not just the national entity. Then about the interplay. These next two slides actually show how AI Act will overlap with the other regulations that we have in the EU. And we don't have time to go all these through, but we use one of the examples, and those who are interested may dig deeper into this picture. There is also European Commission's on EDPB's joint guidelines on interplay between Digital Markets Act and GDPR, which is quite timely released in October, just before our Lexing conference, and the publication is also good because in a charming twist, rulemaker actually published a clarification for its own rules. So I think that's sort of outlines the complexity that we have in the regulation at the moment. But if you take an example, one concrete example, we could have a situation that that we are training AI with a mixed data set, wet scraped plus licensed, which almost certainly contains also personal data and possibly copyright infringing copyrighted images. So under the AI Act, we must show our homework, that we have done it: provenance, representativeness, deduplication, bias testing, evaluations, and general purpose AI transparency. Under the GDPR, we need to have lawful basis for training, clear disclosure, minimization, security, usually data protection, impact assessment because of the inversions and memorization risks. And then there is also a copyright aspect. And I just wanted to say this, take this as an example, because there was a recent decision by Get Images against Stability AI, which actually cleared the situation regarding secondary infringement, but there is still open avenue for primary infringement, which was not discussed in the case due to jurisdictional reasons. But the bottom line in this example is that the same event can actually trigger AI Act, GDPR, and copyright scrutiny at the same time. And how we are able to protect against that kind of situation. So our defense is to have a robust register that links each data set to license terms, opt-outs, flags personal data, special categories, and ties all of that to the model version. So we can always say that if the training event is not logged, it didn't happen. So that gives us the conform. So if you need to remember only one thing from this example, let it be this, so that the governance around the training data, so it's no longer nice to have, but under the AI Act penalty regime, it's your first line of defense. Then what we have about the cases, we can put these cases that what we have already to 3 different categories. We have GDPR-inspired cases currently from Italy. I just mentioned here briefly, but let's not focus on that. Then we have the Yettel case, that was the first one citing AI Act, and it's about transparency, human oversight. But regarding the penalties, that is my topic here. So the important is to keep in mind the nebis indictment prohibition of double penalties cases, P-Post and Nordzucker. And there, what we can have as a takeaway is that this principle only provides a limited protection where the facts and legal interests are identical. So actually, the same case might be subject to sanctions under the GDPR and AI Act simultaneously. So businesses will face multi-regime exposure in this. Then finally, about some of the key risk patterns that we see in companies. So the key risks are sort of a fragmented governance, in a sense that in companies, all these teams work in silos like the AI, data protection, product teams, and nobody has a full picture what is happening, and really what is relevant is that authorities will look at the situation holistically as a whole. Also we have unclear roles in the value chain, so we need to update our templates and taking into account that who is the provider, deployer, distributor, and so forth for the AI Act purposes. So we need to update the templates and documentations. And also from documentation point of view, we also have to take into account that technical teams, when they are doing things, those will be actually documented into the documentation that can be then audited for risk management purposes. So there must be a clear risk management file to be ready. And finally, what we see in large-scale IT deliveries is that always when there is a new regulation, there is a tendency to outsource the risks, and many customers are actually sending the liabilities to the suppliers, saying that, okay, if there is a problem, suppliers will handle it. Well, you don't, and you can't actually do it in a way that you have to take ownership also of the regulation and compliance yourself. And then we have the mitigation strategies. So here, and those have been discussed pretty much already on top of the key risk, but hopefully you'll find those useful. So I stop here. I think I've used my time. So thank you very much.
Thank you.
Questions later.
Thank you so much. Thanks for that on the enforcement aspect. Our next speaker is Raffaele Zalone from Lexing, Italy. Oddly enough, in this section where we've had Lexing Mexico, Lexing Finland, now Lexing Italy, bizarrely enough in our Lexing UK office here, we've got lawyers from Mexico, Finland, and indeed Italy. So it's particularly curious and a huge pleasure to welcome the third in this impressive trio. And over to you, Raffaele.
Thanks, Danny, and good morning to all of you. I'm proud of being one of the founding members of the Lexing network, just as Danny was, and as Frederick remembered this morning, and we've been working together for a long time, and I hope we will continue for a long time. Now, coming to the subject of the presentation, it's a very short, and it's what I would call a sad story on one side, because it basically shows how difficult it is for any authority to draft a law that would regulate artificial intelligence. It's very, very difficult. So basically, what they say is the scope, it's very ambitious, establishing the principle applicable to research, development, and so on and so forth, keeping the definitions of the AI regulation. So we're not changing anything from there. The definitions are there, but we will establish the principles. And it goes on in saying that AI must comply with principle of transparency, protection of personal data, accuracy and non-discrimination. And most of all, look at this. This is very important if you consider what has been told about the US and the European election and so on and so forth. AI must not jeopardize the democratic process and must protect the freedom of democratic debate from unlawful interferences. It's very strong. So you would imagine that following this, very high scope definitions, you would have something very, very interesting. And the rest is it's extremely low. It's extremely weak, because basically what Frederick said this morning, the AI regulation is an horizontal regulation. Okay, it covers no matter what kind of product you're talking about, no matter what kind of area the product is used in. This seems to be a vertical regulation because it applies to several sectors. There are 3 articles for healthcare and 1 for intellectual professions, whatever that means. I think it means basically lawyers and engineers and architects, basically, because if you take out the doctors and the medical sector, that's the only one who remains. Working environment, then the judicial and the cybersecurity. But basically, I'm not going into details of all the specific regulation. What it says is what we already know. That is, AI must be transparent. And so as lawyers, for example, we have a duty to inform our customers if we are using AI, why we're using it, and what are the consequences of the use. Now, as a lawyer, what can I say to my customer? What are the consequences? We may win or lose. basically, there's not a whole lot more to say. Or, you know, an engineer, what would he say? You know, that the building will collapse, you know, if it's not used correctly or something like that. In other words, it repeats basically the principles that are already in the regulation, but without specific and different intervention, if you want. And most of all, you know, one of the points is that this concern about working environment. Now, there is a law of 2022 who already regulates the use of AI in the working environment. And in fact, there have been already cases in case law which have been applying that law in against Deliveroo, you know, the delivery system, and okay. So it shows how difficult it is really to implement a law that will regulate this subject. For example, coming back to what we said, protect the freedom of democratic debate. How do you do that? What are the actual principles? What are the actual tools that you have to use in order to do something like this? In the US, there's been a widespread debate on how to regulate algorithms. But is it that what we need? And how would a judge decide whether an algorithm is in fact and indeed is going to be discriminating or not? Is it the algorithm or is the result of the algorithm itself? So it's a very difficult kind of situation where a legislator can find himself, and it's very difficult to basically translate this into an actual and specific and applicable regulation in my point of view. And in fact, what the legislator has said in Italy, we will take another 12 months in order to give more specific regulations in all of these fields, because they didn't know exactly what to do, because, you know, on one side we have a regulation which is very detailed on the way that, you know, high-risk AI system have to be developed, and, you know, all the obligations in terms of documentations and so on and so forth. On the other hand, if you have this I principle, then it's very complicated to decide what to do and how to implement them in practice. So how it's going to be applied in each single sector is still to be seen. In my view, this reflects the difficult problem that we have in applying this regulation, not just to products, but to activities. Because, you know, as lawyers, what is our product? Is the end result of our intellectual work. Is that a product? Is that a product like, you know, the product that we have seen in the all the regulations in the EU and so on? So basically, the whole point is, at this point as we stand, in Italy at least, we're not much more different from Spain, Mark. So be safe. You're not alone from this point of view. But the point is that you have to jump from one to the other, to the other, to the other. You cannot just rely on one regulation at all. You have to see the whole scenario. And in fact, this is, and then I will finish here because it's a different ball game. But I think that as lawyers, we have to give a message to our customers that is, don't look only at one piece of legislation. You have to look at the entire scenario, the entire legal scenario in Europe, because we have the GDPR, we have the AI regulation, we have the Data Act. The Commission is acting against Google now on the basis of the Data Act. It's not acting on the basis of anything else. So you cannot just rely on one piece of regulation. You have to look at the whole environment and the whole legal scenario that has been built by the European legislators. That's about all. So if you have any question, thank you very much.
Thanks, Raffaele. Are there any questions for any of those three speakers on enforcement? If not, it will move on to the next section, which is on sector-specific regulation amongst the EU Act. And I'm very pleased and honoured to welcome our Lexing Sweden member, Katarina. Over to you, Katarina.
Thank you, Danny. Finance, healthcare, and automotive are three industries where AI systems will and have made a major impact on new opportunities. And each industry, however, faces unique compliance requirements. Let me see. So I will give you an overview of these three industries. On more practical side, how the AI Act affects these sectors. The financial industry, here we have seen that there has been a lot of fintech companies entering the market, which being market drivers of AI system in data-driven services and embracing new technology to be efficient and cost-driven and also to defect fraudulent activities. And AI system brings benefit, but at the same time it brings risk to the financial market. And the Act are taking in consideration these risks. And here I'm going to give you a picture of the major high risks areas. Credit scoring is defined as such an area, and it's defined under Annex 3, meaning credit scoring evaluating the creditworthiness of natural persons and also to credit score these natural persons. So it's a huge harm if wrong done for these kind of persons. The other area is eligibility and pricing of insurance. And this is systems that risk assess and price these areas for natural persons and in life and health insurances. These are also considered as high-risk areas. All the industries that we cover today using massively general-purpose AI. And the industry doesn't have increased or decreased requirements on them. When using this area, they need to fulfill, as earlier mentioned today, transparency requirements and fulfilling documentations requirement, copyright policy, and training data summary. When it comes to this sector, the EU AI Act has mentioned that there is no need of duplication because this sector, there is so many financial regulations with already compliance requirements for the companies. So whenever there is additional requirement on the EU Act, the basic or already implemented policies and structure could be used and then adding on these requirements. This is a report from OECD 2024, and here we can see a summary of the uses of AI in finance. And the main sector is for customer relations, using AI bots for onboarding clients, for interaction with question and answer in the industry. The second area is process automation. And here it's used for back office operation and efficiency. The third category is fraud detection and prevention. This is a very important area. And here, as I mentioned, there's a lot of fintech companies entering this market and providing these kind of services for the industry, and basing this kind of system on massive collection of data for predicting behavior to identify fraud behavior or money laundering. And what are the risks then? This is also the source from OECD, showing that the main risk here is bias and discrimination. Meaning that any AI system that gives an output which will discriminate a specific group based on ages or gender or minority groups can have a major impact on a person. They can be excluded from financial services. And the second one is process automation. No, sorry. Sorry, I have the picture wrong here. But sorry. The second one is market manipulation, and that means yes, as the data is based on historical data, any misuse can have an important impact for the providers in the market. The third one is cybersecurity. AI systems very vulnerable, and financial sector is a focus for any kind of deep fakes or phishing or cyber attacks. This is also a source of OECD from 2024. So I wanted to give it more to a practical view. So I've given you 3 Swedish cases here today. This is a Stockholm-based company, and it's an account information service provider, and provides and deploys an AI system that's used for real-time assessment of creditworthiness when it comes to loan applications. So it's defined as a high-risk system. And credit scoring companies like this will face significant scrutiny when it comes to the input and output of the systems. Because particularly concerning fundamental rights and leading to discrimination. So the company, to fulfill the act, this company needs to implement and maintain a robust and risk management system. It needs to ensure the system is trained and tested with sufficient data sets. And thirdly, maintain documentation and traceability to ensure that proper records are kept. And of course, it needs a human oversight to put in place adequate human oversight measures to enable natural person to correctly interpret the AI system. And also to educate and make the staff aware about the risks using this kind of AI system, to be able to maintain and handling and mitigate risk when using it. And what are the pros and cons then in this sector? Here the cons are more or less same for all the industries. We have mentioned that already today. It requires a lot of changes and redevelopment of the systems to fulfill the requirements. It's also a high barrier for SME companies to enter the market. However, we will see what the omnibus will lead to when it comes to the massive fulfillment of requirements. The positive side with having this AI Act, it is that it's reducing the bias and discrimination. And it's also that it's ban services that is unacceptable, like manipulation, social scoring, biometric. And EU has also, as a suggestion, will have a European data space and to share data to improve AI models and also to use it for the research area. And a lot of regulation in this area is already going towards sharing of data. We have today the existing open banking, where sharing data is required in that sector. FIDA is coming, which is a new coming regulation, which means that even additional financial services will also be required to share data. And then we have the Data Act and Data Governance Act, which means that it puts requirement on the platform providers also sharing data. I will now switch over to the health industry. And looking into this industry, the Act have identified 2 high-risk areas here in accordance with Annex 1 and also 3. You can see that AI systems that are intended to be used as safety components of products, as defined in the already existing union harmonization legislation. These kind of services are defined as high-risk services. The second area is access to essential services. This here we have AI systems that evaluate eligibility for healthcare services and also priority in the dispatching of emergency first response services. Very important and will have a lot of effects on natural persons. So it's a high risk kind of systems. When it comes to this sector, there are exclusions for this industry from prohibited AI in 2 areas: inferring emotions. So for medical or safety reasons, inferring emotions, handling AI systems can be used for therapeutic purposes. The second area is manipulative practices, which also are prohibited under the Act. But in this area for psychological treatment, they can be used. So where is the AI Act mainly used in the sector? This is a report from IBM BCG summarizing 5 areas. And the first area is disease detection and diagnosis. So AI enhancing accuracy and enables earlier detection, often leading to less invasive and more cost-effective treatment options. The second area is personalized disease treatment. And here we can see AI-driven digital twins that also been entered on the market. AI-driven personalized treatment plan can complement traditional ones. The third area is clinical trial efficiency. Here, algorithms analyze electronic health records to identify eligible patients much faster than manual screening. And the fourth area accelerate drug development. Drugs is very cost and time consuming area. And AI could help to reduce the cost of developing new medicine in primarily two ways: creating better drugs and designs, and also finding promising new drug combinations. The fifth area is optimization, operation and administrative tasks. And here AI can reduce the cost and administrative task when it comes to scheduling, when it comes to billing, and also electronic health management, records management. So I would like to jump to these challenges. Which are the challenges for using AI in this area? Clinicians and also consumers has lack of using systems here, as they are not aware of how the decision is taken and which data is based for the decisions. So it's a lack of trust in the industry. Data security and privacy has to come, it's because a lot of providers here, AI system providers here, are private, and it's sensitive data. So there is a question to use this kind of AI system providers. Lack of liability and accountability. It's not obvious who is liable, if it's the provider, deployer, or the institute. Complexity of regulatory landscape. There's so many new AI technology systems and services getting into this market, and it's very hard to get an oversight of what it does of the liability in the sector. So there's really questioning for the complexity of the regulation. Lack of data standardization, and that means that there's multi-forma and silo systems, and that is hindering the interoperability and the model robustness. Yes, I think the time is running, so. Sorry, this is the second case I wanted to show you from this sector. So this is also a Stockholm-based health tech company that develops AI-powered medical scribe software. Automatically generates that in real time when the clinicians meet the patient. And this is a minimal risk, classified as a minimal risk system. However, you need to, and the interesting with this system is that it gains more or less 1 hour per clinician per day, which can be then used for meeting more clients. This kind of system, however, they need to fulfill the transparency. So if it's not obvious, they need to inform that the journals made through the AI systems are produced through an AI system. And what are the pros and cons when it comes to this sector? Clinicians become responsible for the AI decisions, so creating then potential professional liability concerns. And on the positive side, we have exclusion from prohibited AI when it comes to the two areas I mentioned. Emotions and also manipulative kind of systems. In this area, in this sector, in March 2025, European health data space was established, and that is interesting. It enables secondary use of health data for research, innovation, and AI development under strict governments. So developers can leverage large standardized data set across Europe to train and validate AI models. And now I will get into the final sector here today, automotive industry. So the automotive industry is another heavy user of AI. And maybe everyone is aware about that, but it's systems are driver assistance systems, and also to predict maintenance. So the Act then have identified two high-risk areas in this sector. We have safety components of products that's covered under the already existing legislations. And also the critical infrastructure, safety components that is used for management and operation of road traffic. That is also identified as a high-risk system. There is also an exclusion in this sector when it comes to emotion recognition. One of the major cause for accidents are fatigue. And to be able to prevent these kind of accidents, there's exclusion to use these detective emotion detections when to identify for the driver, pilots or car drivers, they identify the eye changes or the head changes or the blinking, and then to identify, predict any kind of fatigue. So, according to the OECD source, we can then see 5 areas where AI has been used in the industry or are used in this industry. It's this advanced driver assistance system, assistance to the car driver, and which are in the vehicle, and this kind of system then are real-time collecting data from the environment around the car, and the driver can use it for parking or whenever they go over the line in the traffic, the car will automatically react. The second area is predictive maintenance and diagnostic. This is real-time collection of data when it comes to the car, so to predict any maintenance and the need for that. The third area is personalized in-car experience, and that has to do with voice assistants and virtual assistants that are powered by AI, and for the driver to control the climate or navigation systems. And the fourth area is a tricky area, that is autonomous driving. And this is massive of data required for predicting the use of a car in traffic. If you look into this, it's a system that combines LiDAR, radar, cameras, and use algorithms to identify and to predict a pattern, to predict pedestrians walking in the street, to predict cars and the route, and collecting all this kind of data from the environment. And today the cars are able to predict 5 seconds ahead in driving, which is quite amazing. And then to let the system help to act. The fifth and last for this industry is detecting the physical state of fatigue, and I already covered that. Then we are going over to the case. And this is a Swedish case based in Gothenburg. Very interesting company, which is then producing, it's an AI-driven software for advanced ADAS technology and also self-driven technologies. So it's classified as a high-risk system. And one of the obstacles for for doing this or for having this kind of system, it's this massive of data that you need. Because every millisecond, there needs to be a decision taken. So you can understand all the logs to be kept and all the data to be kept and to stored. So that's a tricky thing. This kind of companies, high-risk company in this area, so they need to ensure the development data set that it's trained and validated and tested to prevent biased outcome. Secondly, they need appropriate level of accuracy, robustness on cybersecurity. Thirdly, the AI system must be designed to be effectively overseen by natural persons. And here, for example, they can introduce a stop button for this kind of functionality. And fourth, the testing of the system. And if the company is temporarily testing the system for its intended purpose in the real world, they need to be registered and supervised, and ideally to do it in the AI sandbox that is implemented all over the nations in EU. So what are the pros and cons? As I already mentioned, maintaining detailed logs, decision made by AI for automatic driven cars. It's an obstacle. The positive side is that the Act is requirement that AI systems that they are trained and not just how they are performing. It also puts a lot of accountability across the chain here. So for this industry, it's very important to put the contracting correct to the liability and all the different clauses to cover the chain. Both the providers and the manufacturers, all are responsible. And as I already mentioned, there are sandboxes to test the system, which is very important to do, and where you can exchange experiences. Yes, I think that was my last page.
Katerina,
So,
thank you so
thank you.
much. Incredibly thought-provoking, especially drilling down to those key sectors for us as advisors, but also as individuals and consumers who will be obviously subject to insurance applications, autonomous vehicles, and health checks as well. So incredibly important. I've got quite a few questions, but I think what we'll do is we'll park the questions until the end of the next talk, and if not, we'll just have to speak to Katerina over lunch and tea. And in the meantime, welcome our next speaker, who's from Lexing, Greece, Nicholas Papadopoulos, who will be speaking about the compliance challenges as well. So thanks very much for Nicholas coming over, and very much looking forward to hearing your presentation. Thank you.
Thank you, Danny. Well, thank you to everyone for being here and to everyone watching online. I will also explore today compliance challenges and the opportunity for self-regulation concerning AI components in two different sectors. We're going to pick up where Katarina left off with autonomous vehicles and touch upon the Greek legislation concerning AI automation in the automotive sector, which is a bit specific, and also we will touch upon AI in social media platforms used for content review, and finally there are some challenges and key takeaways on this aspects. We chose those two sectors because we find them at the opposite sides of the spectrum. In the automotive sector, there are obligations and requirements for high safety, high liability, and there are hybrid systems, software and hardware. Whereas in social media platforms, there are high volume of data, and there is a soft law ecosystem dominated by system risk management, especially nowadays. Starting with the autonomous vehicles in Greece, there is specific provision in the road traffic code implemented this year in September of 2025, allowing limitless driverless circulation of urban buses and light vehicles, but this is only under the purpose of pilot or research projects. There is an interesting backstory to this provision. Around 10 years ago, there was a trial of such autonomous vehicles in Trikala, which is like a rural municipality in Greece, and there were engineers and legal professionals, and they tested urban buses mostly, but also light vehicles where no driver was inside the vehicle, or there was a driver but only had the overall control if something happened. And then they devised this procedure in order to test those vehicles without driver in 4 steps, and then they were under the constant monitoring from a control center where they had to have a person in control of each vehicle, which was considered as a driver for the purposes of the road traffic legislation. This is a framework which is used in effect as a regulatory sandbox. They have fixed routes and defined periods of time where they can test these drivers under the remote supervision from the control center. And at first there is someone inside the car and there are no passengers. This is the first level, and the final level, the 4th level, there is no driver inside the car, there are passengers, and everything is controlled by the control center. And as Katarina said, there are volumes of data that need to be processed for these to work. So in every case, any live monitoring requires consultation and approval from the Greek Data Protection Authority. And this is a perfect example, in our opinion, where AI Act is colliding with existing sectoral legislation, the road traffic legislation. So in short, Greece has a working regime for autonomous vehicles, but pilot only for the moment. And it's an interesting case where we see national legislation enabling innovation while still remaining legally conservative, considering that this is only for research projects and not for widespread deployment of autonomous vehicles. And we have a case example, which is remote parking. This is an option that is growing in the autonomous vehicles industry. Under the Greek road traffic legislation, it would be considered as a level 4 feature, meaning there is no driver inside the car, but there are passengers. And if I'm not mistaken, this is already available in some countries. In Greece, this would be illegal for the time being, because there needs to be a driver in the car, and there are also specific provisions scattered around in a road traffic code which would prevent us from considering such a component as legal, as compliant with the Greek legislation. For example, that every moving vehicle must have a driver inside, that braking must be controlled from the driving position, therefore not from the control center. There is also a broad ban on mobile device use inside the car while driving, and if this is operated from an app or from a built-in component of the car, it could still be illegal. And also there is general duty of prudence covering the driving, and when the driver steps out of the car to use his application in order to park remotely, probably this would be in breach of this provision. So remote parking becomes a perfect compliance metaphor, considering that the technology is already here. This can be done, but the legal authorization lags behind for specific purposes. And we would be interested to see how this could be devised under self-regulatory standards, trying to create a bridge between what the technology can currently provide and what the legal standing is today. So moving on to I also regarding remote parking, it's important to say that this can still be legal if it's operated under the approved pilot research programs, and we are currently waiting to see such projects being finalized in Greece to see whether the next step would be to update the legislation, embedding into the legislation what the results of these test programs would be. Moving on to social media platforms, it is something that is used in different platforms, not only it's not platform specific, and there is a convergence of different digital rights. For example, the AI Act, as analyzed by the previous speakers, but also the Digital Services Act, the DSA. And there are moderation systems in place which are used to detect hate speech, incitement, radicalization, counterfeit goods, scams, and of course child sexual abuse as well. And there are general purpose classifiers which are adapted for safety tasks, and under the AI Act they may fall under high risk AI because they are used to make consequential moderation decisions, sometimes even without human oversight, or could also fall under the obligations for transparency in limited risk cases, when they also interact with individuals. And there are also examples of chatbots that interact with human users when the human user wants to flag content as infringing the platform terms and conditions, or the legislation for that matter. There are also DSA obligations, which in some cases are heavier than the AI Act. For example, there are mandatory risk assessments, there are audit obligations for very large online platforms, and there are also rights for access to data for auditors and researchers, and there are obligations for explainability when automated moderation affects the user content. And in essence, in social media platforms, we observe a dual compliance burden, because at the same time AI Act and the DSA are governing different aspects of the same environment. The AI Act governing the design and the development and the technical controls of the moderation system, and the DSA is covering the deployment, the government, the transparency, and the system, the risk mitigation of the platform system. And we can sometimes observe errors in moderation, false positives, for example, removing something that should not be removed, all false negatives, content remaining online where it shouldn't be, and also inconsistent enforcement, which can trigger systemic risk obligations under the DSA. And in those cases, we have observed that self-regulation sometimes is very helpful. For example, most major platforms are also using self-regulatory frameworks such as the EU Code of Practice on Disinformation and the Code of Conduct on Countering Illegal Hate Speech. And these instruments are not solely voluntary, but they are also recognized by the Commission as on the right track for the regulation of this specific sector as co-regulatory tools. And they promote transparency and external audits, and they are allowing for the cooperation of the platforms with fact-checking networks and academic partners and researchers. And ultimately, AI moderation on social media also indicates from a different way compared to the automotive industry that sometimes innovation outpaces regulation, and the self-regulation is providing the bridge to gap over this gap between innovation and regulation, because both legal and ethical accountability is still there despite regulation trying to catch up with new developments in tech department. And in both sectors, I think the goal is not to eliminate automation, but to embed on the new technologies transparency, explainability, and of course human control in every decision that is affecting users and humans in general. So to wrap up, let's see some legal challenges and some key takeaways from this presentation. It's important to start with the fact that compliance under the AI Act is not a one-time tick box exercise, and also it's not solely about the AI, but we have to examine this piece of legislation in convergence with the sectoral legislation, depending on the sector and the industry. And it's also an ongoing governance system. And sometimes it requires cooperation with other faculties, let's say engineers, working with lawyers and also with data scientists to build this ecosystem that is covering the overall obligations stemming from the AI Act. Second, compliance must be sector-specific, but when the sectorial law is drafted, the law enforcement should also take into account that they have to align with overall obligations like cybersecurity obligations, safety frameworks, type approval processes for the autonomous vehicles, and traffic law for autonomous vehicles. And also regarding platforms, they have to align with the DSA risk governance and the transparency duties. And also there are fundamental rights on top of this structure. And third, that self-regulation is, of course, is optional, but sometimes it feels that it's no longer optional in some cases where we try to find a way to maintain our ethical commitments in different sectors. And that's why, for example, there's a long going on discussion about ethical committees in most major sectors. And finally, it's important to keep discussing the cultural shift. For example, of course, the sanctions are important, and it's always a way to encourage clients to take action. But compliance is not always about avoiding sanctions, but it's also about establishing both technical and social legitimacy for artificial intelligence systems. And this is, in our opinion, the direction of the EU digital regulation. Also very interested in seeing what's going to happen in Wednesday with the digital omnibus will be presented. And I'd be very happy to discuss if there are sector-specific provisions in any of your countries regarding autonomous vehicles. Thank you very much.
Thank you so much, Nicolas. We've got a few minutes for questions for Nicolas or Katarina. So any questions out there? Yeah.
I wanted to ask about the common risk mitigation strategies that the companies are employing to handle this bouquet of technology regulations, especially to Mr. Zilwan.
Okay, so I'm just repeating it for the online viewers. So it's the compliance strategies for
This multiple technology regulations, like this cross-sectoral tech regulations, the DSA, the DMA, the GDPR, the AI Act.
sounds like that's another full conference. Okay. Well, see if there are any other questions as well before we ask Rafael if you've got anything in particular. I mean, do you want to add anything to that? Maybe grab the microphone. Or...
Okay. Well, thank you for your questions. Above all, thank you for thinking that I can answer the question. It's very difficult because I think you have to look at the specifics of each situation and each process or product that you want to regulate. Okay, so a customer comes to you and asks you, I have a new product and what are the implications and so on and so forth. And I think that before answering, you have to look at the result of the product. So what is it going to do? How is it going to affect people? How is it going to react with the other products in the environment? I think that on one side, I mentioned that there is a law in Italy from 2022 that regulates the use of AI in employment, and it basically says you have to you have to look at where the AI is used. Okay, so in what sector of the activity the AI is used, what is the consequence of the use? And from that, you have to try and determine what is the law applicable, because you can use personal data, and then you have to apply, the GDPR, or you don't use personal data, or the use is limited, and therefore you would have to apply other regulations. And you have to try to understand then how it moves within the realm of competitors and the general market. So it's very difficult to try and give, a recipe to say, okay, you just do this, put some salt and pepper and then that's all. You have to really look at the entire realm of the consequences of the product and how it works and how it interacts. Because again, coming back to what I was saying before, the regulation of the algorithms, but the algorithms are based on instructions which are given by humans. And that's the whole point. This is what drives then the final result. So in the meantime, there is a number of operations and calculations and use of data and so on and so forth. I couldn't care less about them. All I care is what it comes, where it comes from and where it arrives. And that's what's going to drive you to tell you, what regulation to use, because only in this way you can possibly find a solution to this.
Thanks, Raffaele. Any other questions? Otherwise, I've got one for Katarina. Now, a few years ago, after I'd actually spoken about at a Lexing annual conference, I think it was in Paris, on autonomous driving, I spoke to an engineer at one of the leading car manufacturers, and I said, is it true, as I thought, that they have to identify which target to hit in a crash scenario? And he actually confirmed my understanding that yes, they do program the autonomous cars who to hit in a accident scenario. Now, what I'd like to know from Katarina, in her view, will the EU AI Act save us lawyers from being number one on that hit list? Can we hope that they can't use AI to determine who is a lawyer in a car crash scenario?
No. No, but in this, of course, it's very interesting to understand how does this automatic cars function, and to be able to do that is to identify all the assets, all the pedestrians, everything in the environment, and that is massive of data, and that's why they use all these lasers and cameras and imagine then a society where the car goes through. How many data is not necessary to collect them to be able to hit the lawyer? Was there an answer?
Well, on that note, let's go and have some lunch. Okay, thank you very much to all the speakers this morning and to the audience for staying with us. So let's chat further over lunch, and we will reconvene at 1:30. Thank you. Okay, so the afternoon's going to commence with UK perspective, given that for better or for worse, we're no longer part of the European Union, so the EU AI Act does not apply directly in the UK. So what we'll do is we'll hand over to my fellow partner, Jose Saras, who heads up our data privacy team, amongst other levels in terms of the commercial and telecoms work he does. Jose's ranked band one in Chambers for his data privacy and security work in fintech in particular. And it's great to have him. He's not 100%, so I'm kind of on standby to help him through, but very grateful that you've made the effort, despite not being 100%, to come and share your expertise. So over to you, Jose.
Thank you, Danny. I think the idea is just to make this session as interactive as possible, and also just have a discussion with Danny also about certain points. So here we're going to discuss the UK approach to AI regulation and why is this approach important. And why is this approach important? The Global AI Index has ranked the UK as a top 5 country in the world in terms of investment and innovation and implementation. That's the reason why the UK angle is important, at least for us, for the UK lawyers. So how UK regulation differs from the EU AI Act? So I just want to ask the audience, do you think the UK has taken the same approach as the European Union, or it went opposite way? What do you think? But yes, it went completely opposite way. So the UK legal system, just start with the basis, is based on common law, which is a mix of statutory law and the interpretation from the UK courts. Obviously, we have statutory law on data protection, intellectual property, human rights, but as you are aware, 5 years ago, the UK left the European Union. Some of the legislation has been retained, but UK is gradually departing from it. I done something wrong? So, completely opposite approach to the European Union. There's no specific AI statutory law, despite several attempts. There's a white paper. There was in 2023 a white paper and consultation, followed by a white paper, and then followed by the consultation, and where it was set up like 5 main overarching principles that need to be developed by sectorial regulators, by soft law policy. So the idea is just to keep pro-innovation and pro-safety approach, just to make sure AI is not steeped by prescriptive regulation, and just to make sure that the UK become a global leader on AI. And so this is the thought process of the UK government. This slide and the next slide describe this in detail. You will get the slides after this. So it started with the national AI strategy, then the AI white paper I mentioned, consultation that confirmed widely the AI paper. So 5 overarching principles, regulatory guidance, and then also soft policy initiatives. There have been several attempts to pass AI law, but none of them have been successful. One of the latest was the intention to pass an AI law to target the most powerful AI models. This law wasn't passed. The last attempt is a discussion about an AI law that will focus on safety and intellectual property protection. And Danny, we were mentioning another point here about the investment. Anyway, we'll go. So as I mentioned, soft law and policy initiatives are part of this evolving regulatory system. And AI Security Institute, international leadership and collaboration, there are many institutions that are regulating in parallel. So what are the proposals for AI governance and sector-specific frameworks? Here you have the 5 principles we mentioned: safety, security and robustness, appropriate transparency, explainability, fairness, accountability, contestability and redress. These principles, these cross-sector principles are developed by regulators, sectorial regulators. The key regulators on digital and online sectors are the ICO, Data Protection Regulator, the CMA, the Competition Regulator, Ofcom, the Communications and Broadcasting Regulator, and the FCA. These 4 form a forum of regulators that aim to combine regulation just to, on AI. One of the most active regulators is the ICO. Here you see several guidance and initiatives published by the ICO. The first one was a guidance on AI and data protection. And there's an audit report on AI in recruitment. There's a consultation on Gen AI and also on AI biometric strategy. So the ICO has been very, very active. So all this guidance is voluntary, but it's very important in order to understand their thought process. There are also joint initiatives between the data protection regulator and the competition regulator, such as a joint statement on AI foundation models. There are also initiatives from Ofcom on Gen AI tools. So there are a lot of initiatives around, as you see. And AI growth is a soft policy initiative on AI is an AI regulated sandbox. So this is my final slide. I just mentioned at the beginning that the AI was ranked top 5, at least in this guide. I think the adoption is still slow, but the amount of investment lined up is staggering. So I think it's worth understanding the UK angle, which is evolving on regulatory policy, which is constantly evolving. And that's me.
Thanks, Jose. I think I'll just pick up on a couple points before we hand over to my colleague Sylvia. So I think it's, you've seen the difference in approach, and I think one of the overarching underlying unwritten messages, the UK seems to be approaching it from how can we generate and boost the economy through AI, ultimately. And actually, no surprise to see a huge deal signed with, Mr. Trump's America. It's meant to be, figures range between 30 and 100+ billion in terms of how they see the benefit of that deal in terms of AI investments. So, given that the government in the UK is struggling economically to an extent, I think the approach, they're seeing this as a business revenue and opportunity to take advantage of the fact that they are not part of the European Union and to make pro-business decisions and encourage investment, whereas I see the EU maybe looks at the protection of individuals in terms of their freedoms and data privacy, etc., being harmed by the use of AI. So I think that is very much the approach that the UK, and the differences, for better or for worse, but the UK is certainly looking at it from a view to stimulate the local economy. And obviously that could be dangers along the way, and in the meantime, as I say, making the most of the fact that maybe there isn't a UK AI Act. These regulators are already implementing those 5 key principles that Jose helpfully mentioned before. So I think that's my view, but we'll take questions later. But now we'll look at UK perspective on the copyright and AI, and I'll hand you over to Sylvia Eriksson. Come.
Hi, everyone. Good afternoon. So as most of you know, content creators and rights holders, they have been taking legal actions against tech companies and AI developers across the globe for scraping their copyrighted content online to train generative AI without their permission and without remuneration. So let's dive a little into that. Most of you probably know these terms, but a quick recap. When we say generative artificial intelligence, or simply Gen AI, we're referring to a branch of AI capable of generating new content, such as text, audio, images, by using data to learn patterns and generate these new content. Large language models, which we refer as LLMs, they're a type of Gen AI that generate human-like text. And another important concept here, before we get into the subject, is machine learning, also known as ML, which is a critical component of LLMs because they use large amounts of data to be able to learn the linguistic patterns and mimic the human-like text. And examples of well-known LLMs that use machine learning, as you all know, are ChatGPT, Google's Gemini, and Anthropic Claude. These are just some of the LLM systems that use machine learning. So as we mentioned, the thing with LLMs, with Gen AI, specifically LLM models, is that they use a lot of data to learn the linguistic patterns, to be able to mimic and do what they do, right? And to do that, what they do is they scrape data, mostly from the internet, but also from other sources. using something that we call text and data mining, which is not a new concept, but it's very relevant in the context of training AI. So in a nutshell, TDM is a process of using software and techniques to analyze large volumes of data, to find patterns and extract useful, insightful information. It's computational analysis, basically. And in this slide here, we present a definition from the EU law, specifically the DSM Directive on Copyright Law. It has a definition of text and data mining in the context of copyright. And this EU law particularly, it allows TDM for research purposes and in some instances for commercial purposes, provided that the rights holder have not opted out, meaning that they have not reserved the rights in their works. So why are we mentioning this? Well, it's not in the EU AI Act. So businesses today, at least in the EU, they're relying on this directive. And of course, their member state laws, which transpose this directive, to discuss copyright when AI developers are using their copyrighted works to train Gen AI. However, in the UK, our main copyright statute, which we reproduced here, is the Copyrights, Designs and Patent Acts from 1988. It does not have a similar TDM, text and data mining provisions such as the EU directive, right? So there is a text and data mining provisions, but it only allows text and data mining solely for research purposes, so non-commercial research purposes. But in practice, we know, and as you've probably seen in the recent Getty versus Stability case here in the UK, what's happening in practice is that tech companies and AI developers, they are scraping businesses and individuals' data online and using that to train and develop their AI systems. Whether it's in the UK or even outside the UK, some companies are even doing that with businesses in the UK, but then they're training their AI models outside of the UK, probably to escape from UK jurisdiction. And one thing to be clear here is that text and data mining for training generative AI is usually for commercial purposes. So it's usually going to fall outside the scope of this law, because AI companies, they're training their AI models to generate outputs to provide services for users. Most of these services a lot of them are free, but most of them are paid. So there's not a lot of argument there that it's not used for commercial purposes. So bottom line is that the practices today, they're outside the scope of the law, and they're potentially infringing the law, at least in the eyes of the rights holders. So regardless of which side we think has a stronger argument, the framework here today in the UK is that AI developers, they don't have a legal certainty about exemptions for text and data mining to train and develop their AI models. So on one hand, that's the stance with the AI developers. And on the other hand, the content creator, the rights holders that have these content scraped, they don't have control over how their content is being used, and they're not being remunerated for that. So what's the UK stance on copyright for training Gen AI? Since AI needs data and creators need protection, the UK is trying to balance those interests. So on one side, encouraging innovation so that the AI companies can develop AI and we can boost AI in the UK. And on the other hand, preserving the rights of content creators and rights holders, either through consent or through guaranteeing that they have a fair remuneration for the use of their works. So this is a timeline of UK's position and what's happening with copyright for training AI models. In December 2024, similar to what Jose mentioned from the white paper with the principles, in the end of December 2024, the government also launched a consultation on copyright and artificial intelligence, outlining several policy options to reform the copyright law, the law that we just saw, because it's clearly not fit for purpose. And what was the preferred UK policy option? Because they did have a preferred policy option. The UK's preferred policy option is to create a broad text and data mining exception, meaning to allow AI companies and tech developers to use the copyrighted works, to scrape copyrighted works online, provided that the rights holder haven't opted out. So it's very similar to the EU law, to the DSM directive. So that's the preferred option, policy option of the government from this consultation. Obviously, this received a lot of pushback from content creators and even from policymakers. So in February of this year, the consultation closed, collecting responses from both sides, from the creative industries and from the tech companies. The government is still analyzing the responses to form their policy. But one thing is clear, the tech companies, they want the government to relax the restrictions so that they can access data to train AI models. But the content creators, they want consent, or at least fair remuneration for the use of their works. Also, June of this year, as most of you know, the Data Use and Access Act was enacted. We call it DUA here in the UK. There was a lot of discussion during the passage of this bill. I don't know if you know, but the House of Lords, they aimed to put copyright provisions for training Gen AI in the bill. There was a lot of back and forth between the House of Lords and House of Commons. And ultimately, the government won in the sense that there is no specific AI statutory provisions inside the DUA. What we have in the DUA is very limited provisions on terms of what government has to report back to the government next year. So they do have to do an economic impact assessment on this issue. And also they have to inform their policy making by 2026. So although there's very limited provisions on copyright issues with generative AI, it does lock up the government to give a response next year on that. Also in July of this year, there's expert working groups in the context of the AI and copyright consultation working together to come up with practical solutions that can address both interests in both sides. And we know that the outcome from the expert groups is probably going to inform government's legislative and policy response in the next months. So where does this leave us? What we can say is that the UK is still trying to balance both interests. So on one side, as I said, to encourage innovation and boost AI, and on the other side, also protect the creative industry and the rights holders. So more to come on this. We really don't know what's going to happen, but what happens next will decide whether we'll end up with a framework that addresses both interests. Finally, we can't wrap up without talking about the very famous Getty versus Stability case, which was recently judged by the High Court now in November. As most of you know, Getty is an American company. It's a huge player in the visual contents market, famous for its stock images. And Stability AI is a UK-based AI company, very well known for its Gen AI models, specifically a model called Stable Diffusion, which is a text-to-image model. So basically, the user puts an input, right? Please generate me an image of XYZ. And Stability AI's module would give you an output that was basically reproducing Getty's images from its database. So back in 2023, Getty took legal proceedings against Stability AI here in the UK before the High Court, alleging infringement of its intellectual property rights. So they did claim primary copyright infringement. So using the fact that Stability AI scraped millions of images of its database to train its AI model, and also secondary copyright infringement in terms of possessing, using, and selling an infringing copy, which was basically the outputs of what the model was giving based on the images that it had scraped from Getty's database. Of relevance here for this topic is that even before the judgment of this case now in November, months ago in June, Getty dropped its primary infringement claims, which related to the scraping of its images to train the AI model. And why does this happen? I don't know if anybody knows, but mainly it was due to jurisdictional issues because the case was based on the UK copyright law, the law that we just saw that we reproduced. And what's in scope, it doesn't have extraterritorial effects like other laws. So the acts that they were alleging had to happen here in the UK. So the main reason why they dropped is that they had no evidence that Stability AI had trained its model here in the UK. Actually, there is evidence that they trained its model outside the UK. Some people say it was in the US. It's a US-based company and they use cloud. And so they use cloud and probably local servers to perform the training, the development, the model. And as you know, recently in November, there was a judgment of the case. So they dropped the primary copyright claims, but they continue with the other claims. But unfortunately, the secondary copyright infringement, which related to the importation, the possession, and the selling of an infringing copy, which they were alleging was the AI model itself, also failed. So the High Court considered that an AI model could not constitute an infringing copy under the UK copyright law because it didn't store, it didn't maintain, or even reproduce any of the original copyrighted works of Getty. So that was the main reasoning of the High Court for dismissing these secondary copyright infringement claims. So Getty did win on the trademark infringement because I don't know if you know, but a lot of the images of one of the original models of Stability AI, the images that the AI was outputting had watermarks of Getty. So they did win partially on that. But overall, what we think with this case is that the legal uncertainty remains in the UK as to copyright infringement and using copyrighted materials to train Gen AI. Whether there's going to be a reform of copyright law or a comprehensive AI bill that's going to address this issue, we still don't know. But one thing is certain here in the UK, based on what we explained and how the common law system works here, is that the courts can go to a certain point. They can't stretch the law to a certain extent that it deviates from the original purposes of the law. So they can't really interpret the law to cover something that the original lawmakers did not intend. So, and this was said in the judgment by the High Court. It's a very, very extensive judgment, but basically what they said is that if it's the intention of the policymakers to regulate this issue, to regulate the usage of copyrighted material to train Gen AI, this is something that Parliament and future legislation has to resolve, and the court can only go to a certain limit. So yeah, that's what we have for today. Thank you, and if you have any questions about the regulation of AI in the UK, we put our contact details here. Thank you.
Thank you very much, Sylvia and Jose, my colleagues, for that overview of the UK position. I think, unfortunately, we don't have questions now, but what we'll do is we'll go through to the next speakers, and at the end of this block of talks, we'll hopefully have some time for questions aimed at all of them speakers, or any of the speakers, should I say. So, from our Brazilian-based lawyer here in London, to the Lexing Network Brazilian lawyer based in Sao Paulo, I'm very pleased to welcome Flavia Morad to the podium to talk about extraterritorial effects. It's a terrible word to say. And the international alignment, and again, an international perspective on the what's happening in Europe in terms of AI. So over to Flavia. Thank you very much for making the time and the trip to come over from Brazil to be here.
Thank you very much, Danny. It's a pleasure being here in London, and I thank very much the Lexing Network. It's been a pleasure to work with you and with this group of excellent lawyers that are here with us, and for Danny's hospitality. So, well, as my colleague from Brazil, Sylvia, is a very, very competent Brazilian attorney, she mentioned a lot of cases on UK law and copyright and AI. I'd like to mention, I'd like to do a comparative work, not only talking about the cross-border enforcement, but I'd like to mention a few words about the Brazilian project of law about AI. So Brazil is about to launch its new AI law. It's not approved yet. It is approved, but it's not like sanctioned yet. So we have to wait probably next year, but I don't know if it's going to be next year because we have elections, and as you know, we've been living a very polarized moment right now. So I don't know if it's going to be enacted next year. But anyway, the project of law was supposed to be something very similar to the AI Act. So that's why I'm mentioning this law. And this is something that it's going to affect the whole Latin American countries. So this, for you to have an idea how important this is. And also with a global reach, as the AI Act is. The question is, so if we deal with very special principles like risk-based, like the EU, and levels of compliance, transparency, explainability, the regulation is also very horizontal. Well, Katrina mentioned that we have like some sectorial rules, financial, health, especially. We saw the Greek case on autonomous vehicles. We don't have all that. It's very horizontal and very generic, just to, welcome those modifications after that was explained also this morning. So, however, the law will be strongly based on fundamental rights. I don't know if you know, but the data, personal data was considered by our Supreme Court as a fundamental right. And we wanted this to be the similar case, the similar principle, human-centered. The great challenge there is support also the human-centered principle with innovation. And more complicated than that is that because innovation, most of it doesn't come from the Brazilian market, but from abroad. So we have to welcome new technologies. We have to welcome the development of AI itself, globally speaking, and also protect the Brazilian citizens and have a human-centered approach. So the discussion of the law is more into behavior and documents using AI, but also the use of the product. So the law seems a little bit technical from one side and also very behavioral from another side. So we have data mining, we have copyright, authorization. So in generally speaking, like Silvia said about copyright, the Brazilians provided that we should have an authorization for TDM, text and data mining. However, we are stuck at this moment because it provides for a payment. So we don't know who's going to collect it, if there will be a collective society to receive the money and distribute to the creators, or we're gonna have another kind of control. So let's wait for the following chapters of this Brazilian impact. So, but what I like to say most in this moment with you is that what was curious and what impacts countries like ours is that how are we going to be affected by the AI Act? So some examples. How could the AI Act predict or suggest how a foreign company outside the EU territory will comply with the AI Act and also not be liable to the high risks or to the high penalties we've seen here? So we saw that the product and whatever is involved in the product is going to be regulated. Okay, but how the product itself, since the product was not developed in the EU? So what we've seen is that the effects of and results of this AI product has to have some kind of effect in the EU territory. So, and I was curious to know what could happen in practice, because we are talking that in a very conceptual way, but we have to know what is going on. So as a brief research, for example, a recruitment company based in the US, okay, is hired by a German company to do a selection or recruitment of some candidates. So all the technology and everything is being used in the US to select the candidates, but the effect of this service or this product will be located in Berlin, for example. So the ability to investigate, audit, and sanction non-EU entities will be provided by the AI Act. And there are three walls of cross-border enforcement, which is very difficult in terms of sovereignty, penalties, regulatory sanctions, and also public order and democracy. And although it's not going to be a private dispute, it's going to be like country to country enforceability in the end of the day. So philosophical divergence, that's the critical part. So we don't have any regulatory cooperation between the countries. How should the country do certain things if they have like sovereignty? So should the country forget about their own laws to comply with foreign legislation or regulation? So investigation barriers too, how can you do that? Like in the first example. So algorithm capacity, trade secrets, all those things that are protected by intellectual property, how can you enforce them in another country since they have territorial protection? So attribution problems also, who's going to sanction? Does another country has the power to apply a penalty that was so imposed by EU? So it attempts to address the enforcement problems by requiring then another country in another part of the globe to comply with this. What is then the solution or the intention? So for the enforcement, it is created the authorized representative. And this guy, the AI, becomes the legal target for sanctions. So this guy will be the person responsible for all accountability, organizing the documents, audit. And if he gets to know that there is any infringement regarding the AI system, he has to denounce and maybe terminate the contract. So the laws are using private entities also to have this enforcement in place. So a legal entity is created to represent this product and will be the whistleblower, I believe. We know that there is this kind of person with the GDPR, but not as strong as this. So I leave the question for you. What are the powers of this guy and who this guy is defending? Defending the regulation or defending the person he's working for? So finally, this is my last slide. Given the financial sanctions, because they are very high, we have spoken about those this morning. So how can we do to be like, it's like we are in the middle of a very critical position, because we want to comply as a product owner of an AI system, but we also have a lot of impositions. So we are in the middle of a, crisis, let's say. And we have also a very huge EU market. If I'm outside the EU market and I want to have my product there, I want to know all of those implications. So the strong option, it's financial sanctions, limited economic impact. So maybe we can circumvene by the shell AR loophole, we don't know, or the weak option, that's the digital blockade, and we are going to be banned by the European Union territory, which is not good. So if we are going to defend our own law in detriment of the AI Act, maybe we're not gonna have our product here in Europe, I mean. So I think it's more questions than answers, of course, because this is pretty new. And as my friend Raphael said also this morning, Google was sued by the Data Act, so regulation, and not the AI. So we have to look so broadly and not just look at the AI Act, but many other legislations, regulations that come against this kind of behavior, let's say. So that's it. Thank you very much.
Thank you, Flavia. Real insight and how it's going to be impacting on those companies outside of the European Union. And that brings me on to the next speaker. And we're now really looking at litigation elements. And I'm very pleased to welcome my colleague, Tim Cowan, who chairs our antitrust competition and regulation team. So he'll be sharing his insights. And thank you very much, Tim. Over to you.
Thanks, Danny. Thank you very much. Okay. Hopefully this is going to show a slide, which is mine, if I get it right. There we go. Look, before I start, I thought it would be actually quite a good idea to explain where you are, where you're all sitting today. There's a church out there on the right-hand side, and buried in the floor of that church are the Knights Templar. This is a very old and august order. If you've seen Dan Brown's famous story about the Knights Templar, that's where they're buried. It's featured in the film. It's great. But the reason I mention it is the Knights Templar were the guardians of the church, and they were also the knights that guarded people on the way on their expeditions to Jerusalem, as people who could be trusted when there is a... You all right? Good, thank you. They could be trusted when there is a dispute. And the biggest dispute that's ever been, I think, probably in the temple, and this is the home of many, many disputes, is between King John and the barons. So our king came here and he claimed sanctuary in that church, and he said, I want to be protected from the barons who are after me. And this building is actually the location where they negotiated for a year Magna Carta. Magna Carta, the basis for human rights legislation worldwide. So that's where you're sitting. Having heard what I've heard this afternoon from Jose, really talking about our government walking around in the dark with its eyes closed, looking for a torch, I think it's probably fair to say that's not very different from any other government looking to how to regulate AI. I was going to throw out an idea, which we have actually put forward to our Confederation of British Industry, that there are a lot of people looking at AI wondering what it can be used for. There's a lot of people looking at AI and saying, you're taking my copyrighted material. I'm going to explain the competition issues in a minute. But the fundamental basis for Silicon Valley's enormous investment is that they move fast and break things. So they've raised an enormous amount of money. They're breaking pretty much every law that exists, and they're waiting for people to catch up with them. That's the mechanism. What they're relying on is an insight. The law takes longer than technology. So if people find things useful, you can go out there, you can sell them stuff, or you can just provide it for free. You can build up a customer base. You can get people using your products. And you know, when somebody comes along who's a survivor of all of the laws that's been broken and they sue you, then it takes a long time and you pay them off at the end of the day. That's been a model for the last 20 years or so. Now, that worked to a great extent for companies like Google and Facebook and a wide range of Silicon Valley-based businesses. I think the difficulty now is there's a very, very large number of businesses that are on the wrong side of the dispute. So rather like King John and the barons, what we have is a deep political and public interest concern about what it is that AI is doing. And there needs to be a mechanism to make an accommodation and adjustment, take the good, reject the bad. What we put to the Confederation of British Industry is, look, this is actually an enforcement problem. So Danny said, I'm going to talk about litigation. It's an enforcement problem. If somebody breaks the law, you don't have a right if you don't have a mechanism to enforce it quickly, with the emphasis on quickly. If you're in a digital world, it has to be done very fast. Our legal system isn't really any better than anywhere else, and the US is pretty slow. This is okay here, if you're lucky. It is supposed to be a predictable, certain, objective kind of system in the UK. And it's certainly quicker than other places, but it's still too slow. So the proposal we put forward is a fast-track, public-private mechanism where you can have a dispute resolution subject to arbitration very quickly, typically within 3 months. Now, some people will say, well, you can't possibly get to the right answer in 3 months. It's true. That's the problem of any justice system anywhere. I spent 5 years as a judge. And one thing I can tell you with utter confidence, which is that judgments hopefully are logical and hopefully they investigate all the facts. But there's a lot of work being done by that word, hopefully. In reality, all administrative systems are flawed. So the quicker they get to the decision, the better it is for all concerned. And they may not all be right, but at least they'll be fast. Anyway, that's a proposal we've put forward, which is a possible way out of the conundrum. I'm now going to cover another way out of the conundrum. Sorry, not going backwards. So, where did this all start? Well, for those of you who are looking at the kind of beginning of this wave of AI, I did a contract 25, 30 years ago for decentralized computing using neural networks for University College London. It was a defense application. So neural networks have been around for a very long time. Artificial intelligence, some people would say, is just rebadging computing. Everything's artificial, but there's no intelligence. You can go into all of that. But what really triggered this was Microsoft's investment, quite significant original investment in 2019, but then it doubled up. And in 2023, put 10 billion into OpenAI. So that totally boosted the OpenAI. Why did it do that? If you think when you sit down at your computer every day, you do a search, your computer typically will have a Microsoft operating system on it, and that search will be done on Google. Yes, you might use Bing, but most of the time you don't. So if you're Microsoft, this is a big problem because the search data is going to Google, which isn't Microsoft. You could call it a competitor, but just think of it from Microsoft's point of view. They're not capturing the data, so they can't turn it into advertising, which is useful to you. So you boost OpenAI, have a generative search type system, LLM-based, that uses the underlying Bing search index, and that gives you, it traps the customer within the Microsoft system. That's very, very helpful to Microsoft. You'd have seen recently that what they've done is further deals with other AI. So they're not locking into their own wholly owned AI system. They're simply trying to make sure that people are staying on their part of the computing infrastructure. So that really is kind of the start of this. And what came back as a response from Google was the investment to a much greater extent in Bard, which is now Gemini, and the cases that we are taking on that. I'm going to cover, but I'm going to cover after just doing a quick review. Sylvia talked about the copyright cases. And the copyright cases are many and varied. I'm not going to try and cover all of them. I'm just going to make the point. They're many and varied. Some are winning, some are losing. So they're all over the place. And then maybe there's a way out, which is through the use of competition law. So what you've got here is a slide which will be in your pack. It's interactive. It has a click through to all the competition cases that are currently running. We're involved in quite a few of these. The story behind this is Google built a pretty good search system from 2004 onwards, was king of the search systems until maybe 2012, 2014, has a very efficient system. Until 2008, it was providing a system which takes your web page, it ingests, otherwise known as copies the web page, puts that into an index. The index is databased in various parts of the world. There's a big one in Europe, in Belgium, but then it's cached in various local locations. And that is a copy. There's no question that it's a copy. Google says in its guidelines, until last year at least, this is used and it's useful to you, the copyright owner, the website provider, because we can then take that, we put it through a ranking system that then ranks it in terms of relevance to user query and shows it in a search results page. So from a publisher's point of view, they're taking an opportunity to be found on the internet. And that being found on the internet has become fundamentally important to a very, very large number of businesses. So what happened? Well, from 2008 onwards, Google started putting its own products at the top of search results pages that didn't go through its relevance engine. So I was involved in taking cases for news businesses, image businesses, Getty being one of them, shopping businesses, online shopping, financial businesses, all sorts of different businesses. The European Commission decided to take the shopping case, which is the 2017 case, first one on the list there, fined Google 2.4 billion for self-promotion or discriminating against rivals. That was appealed to the General Court, Google lost. It was appealed to the European Court of Justice and Google lost. And then it came back to the UK court and there's a damages proceeding where we're representing Connexity in that proceeding in the High Court, in the Competition Appeal Tribunal. We started off in the High Court and that's still ongoing. There was a settlement of that case reportedly over the last week in Germany, and we've heard there might have been a settlement in Sweden as well, but we're not sure. The fine is 2.4 billion. The damages being claimed are calculated by the people who are harmed. So there's huge amounts of money involved. Android is a case that Google essentially put its own products on the Android phone. And that case has been picked up by the European Commission, still on appeal in Europe. It's been taken by the US Department of Justice, and Google is facing being broken up both on that case and on another case, which is AdTech, where we're acting for a thing called the Movement for an Open Web in the US. That proceeding is going on both here and there. I'm not going to go through every case because there isn't much time. We can talk about it later. Suffice it to say, go back to that point I made about move fast and break things. These are all cases where Google is basically betting on one thing, which is that it can break all these laws before it really gets stopped. It's now irritating politicians. So Madam Ribera, she's a Vice President Ribera, the new competition commissioner, said 2 weeks ago in the European Parliament, it might have been 3 weeks ago, Google is a recidivist. This is a repeat offender that's deliberately breaking the law. And that's why they fined them 2.95 billion euros in the AdTech case. So we're actually now getting to the point where the political system, I think, is losing its patience with just standard enforcement of the law. And we will see how that pans out. Because ultimately, as I learned when I was representing a monopolist at BT, there is only, this is what the head of regulation said to me, remember, Tim, there's only one monopolist, and that's government. Copyright cases, these are class actions. The reason for putting up class actions is if you take an individual case for copyright infringement, we'll be here forever, right? So what happens, particularly in US law, is you've got the ability to take class actions. Some are going one way. So there's an author's case against Anthropic in Chicago, where there's a settlement of 2-point-something billion and the judge isn't happy about it, so that's going through the process. What's actually taking place here, though, is mass enforcement of a breach of the law. So can you do that here in the UK? Yes, you can. Getty chose to do it on its own, but there is a group action in the UK which could be used, particularly for intellectual property. We're looking at that on behalf of musicians, and session musicians in particular, because, as you may have noticed, music is being made available, what you might not know, so made available by Spotify and the record labels, but what you may not know is that people aren't being paid for the making available. So, you know, that's a mass infringement proceeding that is certainly very possible here. Big problem with the system here is whether you get financing. In the US, you've got mass torts, you've got mass claims, you've got class actions, and a very healthy, supportive mechanism for finance. Here in the UK, that's developed in the last 10 years pretty well, but it's still a bit rocky. And in many countries around the world, financing somebody else's litigation is simply illegal. So there's an opportunity here. The reason I put this up is if you go back to Sylvia's presentation and look at the Getty case, Getty couldn't show what was taking place was actually a copyright infringement. So if you cut through all the fuss and the noise, and at the end of the day, you've got to show a copyright infringement to use copyright law. There is a case when, in the very small typing at the top, which I did on Friday, which is Gemma, which has just been decided in Munich, where the music rights organisation successfully stopped misuse of copyright material in a case. I think it actually involved a Getty image as well, which is adding insult to injury for the Getty people. But it's certainly capable, you know, intellectual property law is capable of being used to prevent AI. It really depends on the evidence that you've got. And that's a major issue in many jurisdictions because you don't have a discovery mechanism. We've got quite an extensive discovery mechanism in the UK. You get more discovery typically in the US than you do in the UK, though. So a lot of those cases that we saw on the previous slide from the US are running pretty well with lots of evidence from the person who's infringing, which is some of the best evidence that you can get. So this talks about on the left, again, to be gone through later perhaps, the Anthropic case. There's then a universal music case which is settled. There's a really intriguing case from Denmark quite recently, where in order to bring to the attention of the person using the material which is published online that it is copyrighted material, some very sharp lawyer in Denmark made it machine readable. So you put your statement online, you put you can't use or you can use the material that you make available online, and they restricted it and said you can't use it for AI purposes. And they got an injunction in a Danish court because the judge said, well, the AI or its owner knew that this wasn't available under a copyright license because it said so in the terms and conditions on the website, and they were machine readable. So if it's as clever as you say it is, it should know that. It's a bit unfair, really, to say that about what is basically a pattern recognition model. It doesn't really understand anything, but the fact it was taken into account by the judge, I think, is quite a useful precedent. What I'm going to talk about here is, well, say that you've got all of the copyright claims under the sun and they're proceeding. What else could you do? Because you don't think you've got the evidence, or you think it could be very difficult to get the evidence. And what we're doing is we've identified, and this is the case of Google. So Google's taking the image or taking the content, it puts it into the index, and then uses the index to train the Gemini model, the large language model, on the index. And then it presents the AI at the top of the page, moving 30% of the page down so other publishers can't be seen. That's like the 2017 case that I talked about in terms of shopping, what Google did in 2017 was put its own shopping website at the top of the web results, just doing the same thing again, this time with an AI model. It squeezes other rivals out of the frame, below the fold. They don't get seen, so they can't make money. So that's an antitrust case or a competition case, because you're taking without permission, it's exploitative abuse, and you're presenting in a discriminatory way. So you're exploiting and you're discriminating. So it's both sides is an abuse of dominance. And we're taking that case and we filed it in June, initially we've actually filed it with Italy as well as the EU and the CMA. The CMA is progressing that under the Digital Markets, Consumers and Competition Act, which is part of our range of competition measures that can be taken here. And the EU is taking it, we're told, or we believe, under old-fashioned Article 102, basic competition law. But on Thursday last week, we were very pleased to see that the part of the case, which actually relates to shopping, has been taken up under the Digital Markets Act. One of the little wrinkles here is that Google's been discriminating against rivals that it doesn't like that are using shopping sites because they're really valuable. There is no altruism in this provision of results to the end user. This is a commercial organization taking for commercial gain. Now, you could run that in copyright, but under the competition rules, if you take for commercial gain and discriminate against rivals and you're dominant, that's another way of hitting it. So what the Digital Markets Act is looking at is the reduction of the ability of rivals to use affiliate networks. Basically, it's price comparison, shopping, coupons, that type of thing, which is frequently used by newspapers. So it's undermining their ability to make money. So what I've talked about here is 4 points. The spiders take the website pages. Google then puts it on an index. Google's page rank, which I've mentioned before, then ranks and then produces a relevant result. And finally, Gemini ingests, takes that and puts it at the top of the page. So that's a competition way of solving the problem. The picture there, which I don't know whether you can see, what this shows here is the top of the page is about 30% taken up by the AI snippet or large language presentation. And, you know, if we're just being really basic about it, rivals are not treated in the same way because Google's product is given 30% of the page and everybody else has to make do with being squeezed in to the rest of it. That's really the guts of the case that we're running at the moment. So conclusions. All LLM that uses others' content is legally questionable. So you've seen all of those copyright cases. Even if you lost a copyright case, you might even have a competition case though. So it depends who it is. If you look at Getty and Stability AI, there's no dominance there. So there's no grounds really for an abuse of dominance case. But if you're dealing with a Google or any one of the big platforms which is dominant and been found dominant in any of those cases, then maybe there is a competition case. If you look at competition cases, we're really looking at commercial impact, which is part of a copyright case. So you have to be using for for commercial purposes. If it's for non-commercial purposes, then you're probably all right. But that's research, and it's not likely. In our case, in the Google case, what we've been finding recently is it's quite likely, we've not got to the bottom of this yet, it's quite likely that the AI overview is taking you to a YouTube video rather than a series of sites. Who owns YouTube? Google does. How much more money does it make from YouTube videos than display advertising? 5, 10 times, right? So it's making more money out of YouTube videos. This is just a mechanism for making money, right? It's not even necessarily more relevant than the original results. So at the beginning there, I talked about Microsoft making that investment in OpenAI. When that investment was made, the CEO of Microsoft said, I'm going to make Google dance. And so far, I think it's fair to say that Microsoft is making Google dance. It's making it respond to the competitive pressure that is OpenAI, and Google's response is to actually do things which are anti-competitive. So, you know, where this ends up is anybody's guess. But I do think there's opportunities across the board to create a more level playing field, principally, I think, ultimately, in a faster legal system. And we can circulate afterwards the proposal for a fast-track arbitration system, which, if enough people get behind it, there are more people harmed by AI than benefit from AI at the moment. And I think that might be a way forward. Okay, thank you.
Thank you, Tim. Sounds like you're going to continue to be incredibly busy. It's unbelievable. And also for flagging, you know, just the practicality of the AI taking up the 30% of the Google search. And that could end up being 60% in a few, and everyone's disappearing from search results. So that's something we can talk about later as well in the coffee break and drinks afterwards. So on another element, there's so many elements to this AI conference. Sebastian Fanti from our Lexing, Switzerland office is going to really look at AI use case in terms of combating fraud in the banking sector. So something that the Swiss know about a fair amount, and so it gives me great pleasure to introduce you to and welcome Sebastian. Over to you.
Thank you. I already beg your pardon for my poor English language. As I have arrived today, I know that I have a lot to learn still to reach the level of knowledge we have heard here. I'm from Lexing, Switzerland. I have worked during 9 months on artificial intelligence. I've gone back to university for the first in Europe certification for lawyers about these topics. And I was before a data privacy commissioner during 9 years for my region. So these are things normally I know well. I wanted to take a case that is well known of all of you, because you have a dad, you have a mom, and sometimes they call you and to ask you just, I have received an email, someone has called me, they ask me to put on a button, what should I do? And this problem is now not only the problem of personal responsibility, but the problem of the responsibility of the banks. And I've written an article, I will send it to you when the book is published in some days, but we were 27 lawyers following this course, and the 12 best have been published. So it was a publication about this case, and what was interesting is that we don't speak together about this, but in fact, the solution of UK was really interesting. I will speak about this at the end of this moment. So in Switzerland, we speak about senior when you're over 55 years old. I'm lucky because I'm only 54. But next year, as my children are telling me each day, I'm an old guy, so I need to take some measures to protect my assets if I had perhaps some bitcoins of money or gold and so on. So we have made a study. We love studies in Switzerland, you know, and we have a special place in Neuchâtel when they learn about criminality. They publish a lot of reports. And on these reports, we have seen that old people are now targets. You know it, I know it. But how much are they interesting for perhaps robbers or criminal persons? And that is the result of this. You know that they don't always tell the truth, because when you have been stolen, you don't want to share it with anybody on earth. You feel bad. So if you speak with your children or with friends, it's already good. But in fact, I have a lot of customers who are coming to my office telling me, yes, are we really protected by secret? Yes. Don't tell my daughter, don't tell my son, don't tell anybody that I have lost this money, because it's a shame for me. I don't want to share it with anybody. Just try to help me, and we don't speak with it about this with anybody else. So when we see 27%, I think it's less than reality, but in fact, it's what they have answered to the inquiry. They lose only 6,437 Swiss francs. That is the normal amounts. When I was Data Privacy Commissioner, I was responsible instead of the police of all the calls when people have lost money after cybercrime. In 1 month in my region, where are only living 300,000 people, I had more than 3 million of Swiss francs stolen. So this is not reality. The people who lose money, they lose much more money than it's right in here, for clear, for sure. But they don't want to tell it. So they explain, yes, I have lost some money, but I don't want to tell you what. So there is another problem in that most of them are between 55 and 64. So you can tell, yes, they can earn money until 64, so this is not problematic. After it will be more problematic. My explanation is that after 64, you don't use perhaps all this stuff. You ask someone to help you. So that could explain why the target is between 55 and 30 and 64. You have the number of targets and so on. But for me, what's important is that these figures should be treated with caution because, as I have explained you, when you ask the people, just explain me what has happened, they don't want to tell too much at the beginning because they are not in confidence. And when someone is just asking them, yes, just tell me if it has happened 1 time, 2 times, 3 times, they don't want to speak too much. So you need to take care of the numbers. The Swiss Federal Police and all the police of the regions are publishing their numbers. But their numbers are totally wrong. This is not the truth. This is another world, you know? This is a world for children. This is a perfect world because the people, when you go to the police station, what they tell you? They tell you, you're responsible. We won't find the people who have done this. It will take us time and we have more important things to do. In some countries, like in England, if I'm really well informed, under a certain amount, police will not do anything. They will tell you it's loss. Just tell it as a loss. We don't lose money with it. So in my city, we are 30,000 people. There was a police station where all the people are going when something wrong has happened. And they made their complaint. They have decided to close the police station. Too many complaints, you know. We cannot work anymore. Everyone is coming. And these lawyers, they are explaining their customers, you don't need a lawyer to make a complaint. Go by yourself, explain what has happened, they need to work. And they tell them, you need to go to the public prosecutor's office. You need to write, you need to explain. That is really difficult. So when I speak about shadow cases, that means you don't have the reality before your eyes. So you cannot understand really which is these criminal elements that are now appearing, which are the methods used, and you cannot fight them. So this is a really wrong way to fight against cybercrime, because if you have the wrong numbers, statistics are all wrong, and you cannot push the pressure on criminal people where you need to put it. I will just tell you what has our authority, banking authority, that is, name is FINMA, explained us about AI. So, you know, in Switzerland, business as usual means you don't have rules. You have the minimal rules we can put on the law. And there was something really special between France, we love France, and Switzerland, is that one guy who was responsible of the Ministry of Economy, he came with 2 books on TV. This book was a Swiss book about labor law. And this book was a French book about labor law. So that means in Switzerland, you don't have a lot of rules. If it works, it works. Auto-regulation will be the first name you will hear of economic, perhaps people and associations. They tell, don't touch to this topic until we have big problems. So they have just given us some principles. You have here this principle, governance, responsibility, that are the same words you can find for insurances, for banks, but for all other small companies. They need to respect equal treatment if they are perhaps proposing services or products. And we have no specialty. In 2024, they have decided to make communication about AI risks. This communication, follows some cases they have received. Because if you want to do something in Switzerland and you're an insurance or bank, you go to the FINMA and you tell to the authority, I will do it like this. I propose you to have these safeguards. I will follow these rules and I will make you a report after 1 year. And authority, what will she say? Yes, of course, interesting. Do it at your own risks. If something wrong happens, we will be there. But normally, as you have seen with Credit Suisse, they will be later there. And the problem is that in our country, we speak a lot about these rules that are inefficient. So they have decided to increase market transparency. What does it mean? Does a bank explain his customers what are the rules she's following? Nobody will explain it. They will speak about secrets. And I will explain you a small story after this. Because I have asked a lot of banks to explain me how they use AI to prevent these cyber crimes. Nobody decided to answer me. But each bank I was in contact with has told me, just send me the result of your job, of your work, We wanted to know which safeguards you are asking us to follow. Because they are afraid of this artificial intelligence. They know that this is a really huge risk for them to pay more, as it happens now, as I know it, in England. So they have presented measures in 7 areas that are general measures. I don't want to tell anything about this because, you have heard it the whole day. Risk inventory and classification, yes, a new thing. Data quality verification, a new thing. No, nothing new about this. All what's necessary to be respected. So, I wanted you to speak about AI Act for Switzerland because as for GDPR, we should have to respect this AI Act in some cases. Big companies like UBS or Omega or such companies, they need to respect this AI Act. If they develop or supply AI systems to entities based in the EU, if they operate AI systems that produce outputs that are used in the EU by customers residing there. So it's the same as for GDPR. We have no decision at the moment from any court of Europe that could be really impressive by the explanations we receive. So we advise our customers to stay safe and to just respect all the rules of AI Act if there is a doubt. These rules are really more tough than our rules that doesn't exist. So that means if you are a big company, you need to respect it, because if you don't, as you have heard, you risk you have some problems. 2 types of companies are really interested in these rules: creditworthiness assessment for granting credit to individuals, and risk assessment and pricing in the health and life insurance. So the big ones, the big companies of Switzerland should respect AI Act. Then, it's a little bit different because you have a more granular regulatory framework, here with AI Act. Then in Switzerland, we have another approach. We have an approach by sector. So we want everyone to come here in Switzerland because we have no rules. So just come here. Let UK, let Europe come to us. We won't make any problem. There is no fine, no penalty, no prosecutor. Everything is cool in Switzerland. So you can come to us. We want to be the first innovation hub for Europe. We are protecting fundamental rights as anybody else, and we are increasing public confidence in AI. That is what our government is saying about AI. We have a thematic and sectoral approach, then adopting a comprehensive horizontal law on AI as in the EU. That means we criticize what all other countries have done. We can do it better, simply, and for less money. So this approach is based on the principle that we have these rules that are general rules, no special rules. Like if you read the AI Act, at the end of the day, you can go and sleep. Because if you understand everything, I don't understand everything. So I have a lot of questions. So in Switzerland, we have decided not to follow this. We want to make our way. So this regulation will be depending on the sector where you are working. Are you a bank? Are you an insurance? Are you public? Are you private? And so we have not decided for the moment what to do. So we need to wait until 2028. I have taken a small comic, you know, because in Switzerland, the fight between innovation and regulation is at the top. As you have perhaps heard, Switzerland has signed, I could say, a contract with the US president. That means we won't tax the GAFA. We won't tax the big companies. We have decided to stay really cool with all these companies. We have no rules about these companies. You have rules. We don't have any rule for the moment. Our rules will appear for such companies in 2028 for the first time. So they don't need to be in Switzerland, to have an office in Switzerland, to respect our laws. So if you are a prosecutor in Switzerland, you need to ask information in Ireland, in the US, and you will have no answer for sure. So what we have signed is the Council of Europe Framework Convention. This is the first binding global instrument. Why have we signed it? Because the person who has made the job was a Swiss guy who was a data privacy commissioner, Jean-Philippe Walter, and we have decided it's only for public authorities, not for private companies, because this is binding, you know. We don't want to have too many rules. So we are staying cool, even if we sign something. Our data protection rules means they are fully applicable to AI cases. So we don't need to change anything. So we have, since it will be like if you have the GDPR and you say everything is in the GDPR, we don't write a line, a word about AI rules. Everything is in it. We have normal rules and we stop it at the moment. We wait and see what other country will do with it. So we have the same rules as in Europe, as in UK about the data protection, because as you perhaps know it, Switzerland is considered as an equality level of data protection like Japan or other countries, so we can exchange a lot of data. And that means we don't have something special to do. So, at the end of this moment, I want to tell you that seniors, you know, age-related risks, you have no rule, nothing to follow. So, that means these people, they are risky people. And when you have a risk, normally you take some measures. So, but nobody has asked you in the law, no authority, no government, no prosecutor to take any rule. So this is a real mystery how in banks they do it. Because I have one case each month, but not for 10,000 pounds, for 100,000 pounds. And when I ask the bank, I have a right to access to my information, to the information of my customers. Give me all information you have about this case. You've spoken with my client, just send me the voice call, okay? They stop every information. They don't want to share it, so we need to go to court and to ask all informations, but you tell me that you have taken some measures when you have known, you have received a call. My customer has told you, I wasn't clicking on the application, okay? It wasn't me. So what did you do? You wait 4 hours and you pay. Why? Is there a system that is preventing such acts in your bank? They don't want to answer. So now we are before the court for a lot of cases because they don't want to reveal what they do and how much time it takes and so on. And perhaps you don't know it, but Swiss banks, they never share their information between themselves. We have regional banks that are banque cantonale. It means this is a region, it can be 2 million of people. They don't exchange information about such cases. So the level of maturity of all the systems is being slow and staying really downstairs. So this problem is a big problem for us. So FINMA, the authority, isn't telling us anything about what needs to be done. And so I needed to find solutions. So that means I needed to ask the banks to change the way they work. For me, the first element that is really important is the KYC. You know, they have a KYC on me. I got 4 children. 2 are in Switzerland and 2 will live in Florida. So that means I have now these 2 children in Florida. I need to pay for them. I can explain you each day. I have 10 credit cards, Revolut, UBS. I have a lot of credit cards because all what I pay from Switzerland in the US for my children are blocked. They tell me, you're not in the US. How can you pay it? But my children, they are 14 and 16. They are asking someone to bring them some stuff. They want to eat, so they call Uber. I pay with my card when they are there. And each week I'm blocked. So I need to call the bank to say, okay, guys, my children are still in Florida. They haven't missed school, so they are not back in Switzerland. Just unblock my card. I can show you. The last time it was for Amazon, $12. They blocked the card. It was an ultra card of Revolut because at the end of the game, I have told them, okay, I take the best card so that I don't have any problem, but the problems are always the same. So that means for credit cards, they have found solutions even for they work and they stop if they have a debt. But that doesn't seems to be the same for all the payments. So the KYC cannot stay like this today. With artificial intelligence, they should ask me a lot of things about my family. They should ask me, yes, where do you buy, perhaps when you go on holiday, where do you buy it? I buy it always at the same agencies. They should know it. They see it. When I go to the casino, they know it. Perhaps you don't know it, but don't take cash money at an ATM in a casino because there is a red flag for this, you know? And so for me, know your customer is the first job to do. Consolidation of bank accounts and precise indication of future use. My father is now on pension, okay? He needs to pay each month this, and this. So I have different bank accounts so that it's automatically paid. I don't care about him because I'm sure that it has been made. And I can switch between these accounts, and if something special happens, the bank will normally, if they take care of it, understand it. Transaction dates. I always pay my loan at this moment of the month. I always pay to my child the first of the month $400 for him to have some money when he's buying something at school. I always pay this at this moment. So what I don't understand is why banks, when they know that transactions are they have ever been made to Lithuania, there is an amount of £50,000 to a Lithuanian bank, and nobody is asking himself, is it normal? But this person has ever paid a penny to any other country than in Switzerland. And the system doesn't detect it. It detects it, that reality, but they don't want us to know how they can really work and stop it. So some banks have decided, okay, I don't pay the same day. My bank has decided. I'm public notary. I make a lot of contracts in the whole Switzerland. So If I want to pay someone, I need to wait 24 hours. So I have told my bank, I agree with it, even if my customers aren't happy because they need to receive money. So they want to receive it as soon as possible. So, but if you have 24 hours more, you need to control more efficiently each Swiss franc that comes out from my bank account. But they don't want it. So something else is to have these statistics. You know, when the people become older, they don't buy a lot of things. They have already fast everything. So they don't go to Dior each week. You know, if you're a woman, you have some bags, perhaps you will receive it for your birthday or something like this. But if you go there 2 times in a month and ever before, there is something wrong perhaps about this. That means my wife is in town with my credit card, so I need to go faster, you know. So you have a maximum monthly expenditure amount. When it's reached, you should ask the people what happens. Is it a special month? You have a lot of things to pay that weren't expected. Splitting and frequency of transactions, you know it. When you have perhaps 2 euros, 2 pounds, or 2 Swiss francs that are going out from an account, you have a red fire, for sure. This is the way they control a lot of things. For me, and I will finish it with it, we have 2 problems. If I tell my dad, you cannot drive anymore, that's the truth, Dad. I'm sorry about this, but you drive really badly. You shouldn't drive because he's already 82. Does he need to drive? Yes, he thinks he needs to drive. So if I tell him, I don't want you to drive anymore, he will be angry. But for sure, he will not be convinced by my arguments. So if you tell to someone who is older than 55, you need to double check each month you pay what this person will do. This person will say you, I'm independent. I have earned all my money by myself. You weren't born. Don't tell me what I need to do. So we need to convince them that this is the right and only way to protect them because they are risky people. They are on a target now. And so this is the first thing to do, to convince them, to let them learn. They come to perhaps a conference or they follow education programs. And then the best way to stop everything is a callback. They call me back when I have spent too much money with my MasterCard. Why don't they call me back when I pay 10,000 pounds to Danny? He will be happy, but this is perhaps a mistake. This is a wrong account, or is it real, this payment? Have I bought something in his office? They call back, but they don't want, because this is too much job, you know? And then the problem is that if you don't do it, you will arrive to the situation. I don't know if this is the truth, because when I have done my job, I was controlling it. But information that were published about UK rules, legal rules, were so different that I couldn't make myself an opinion about the way it's working now in the UK. But as I have understood it, from October 2025, financial institutions will be required to systematically reimburse customers who are victims of fraud, authorized push payment fraud, up to a limit of £85,000. You know, you need to prove some things, because it's not so easy. It's not automatically paid. But this is a rule that is really interesting. It means that responsibilities are not the same, because we speak in French about asymmétrie des moyens. That means the bank has more money to prevent fraud than the customer. So if the banks aren't understanding that the decisions in court will change quickly, they will face a lot of responsibility for according to lawsuits, for sure. Because now if I have a case, I don't take time to to tell myself, should I go before the court or not? I go before the court, you know, I go, because I know how they can succeed to prevent cybercrime. And they don't want to do it because they don't want to have an objective responsibility without any fault. And that should be the next legal system in Switzerland. Thank you very much.
Thank you, Sebastian. It's quite interesting. Unfortunately, criminals are using AI increasingly. And we work for some companies, especially actually in the telecoms sector, using telecoms data to combat fraud. And bizarrely enough, it's actually very difficult for them to comply with GDPR. And it may be the case even with the EU AI Act, that actually some of the solutions to combat this AI fraud may themselves infringe the AI Act. So we need to be very, very careful with that balance, but it's something to think about. But yeah, the fraud aspects are, are scary, but let's hope the solutions work, and it's going to be very, very important to devise solutions that somehow have all that data, call Sebastian, know when Sebastian's making payment, which isn't a regular one, yet do so in compliance with GDPR and the AI Act and whatever regulation they have in Switzerland and down the line in the UK. Now, we've got time for one question before we break to any of the speakers in the afternoon. If not, feel free to chat to them over the upcoming coffee break. So, okay, so what we will do, it's been a long, long session so far, so well done for staying with us, and we'll have the final coffee break before our last speakers, and afterwards a nice long drink session. So thank you very much once again to the speakers this afternoon. Thank you. Okay, thanks for coming back for the final push until we have a really, until the drinks. So now we really want to focus on practical steps going forward. So what do? We've seen all these issues. How do we begin to tackle them head on? So we're going to have a couple of speakers this afternoon, starting with David Late, who's from Lexing, South Africa. Lexing, South Africa kindly hosted us a couple of years ago in sunny Cape Town, which was, I'm still very, very grateful to. Actually, should have said also to Sebastian Vanti. I mean, we have these Lexing conferences all around the world, and just had incredible memories. And Sebastian, when he hosted it in Switzerland, from the conference center, there was a ski lift up the mountain connected into Verbia, so something I'll never forget. We don't quite have a ski lift here, but we have other treats here. And actually, after the drinks, please have a wander around, because it's really worth looking at. It is on the tourist and walking tours of London. But coming back to AI, and let's look forward to hearing from David on practical governance for next gen AI, and with an emphasis on practical, which will be rather important given all the high-level difficult issues to tackle. So over to you, David. Thank you.
Brilliant. Thank you very much, Danny, and thank you to the whole team here in London for hosting us. Thank you to all of you for sticking around. You must really like AI to be still here at the end of the day, so we'll try and make it worth your while. So yeah, all my colleagues today have really put some great effort into kind of setting the scene from a legal perspective. I want to dive a bit more into the technology and kind of tell some stories about where we are and where we might be going. So to quote that old quote, it's difficult to make predictions, particularly about the future, and that's exactly what I'm going to do today. So let's try and look at the state of technology and extrapolate some stuff. So I want to talk about 4 things that we're seeing these days. So the first one is semiconductors, so the chips, right? These are the little bits of silicon that are powering the AI revolution. And I'm not a microelectronics engineer. I'm just a nerdy lawyer who likes to watch YouTube videos and give advertising money to US corporates by doing so. But what I've learned there, and what really fascinated me, is the entire industry that's driving these cutting-edge AI chips really flows through one or two key companies that drive this whole thing around the world. So the one is a Dutch company called ASML, right? Now they build the ultraviolet lithography machines that actually etch and produce these chips. The kind of current state of the art is something called extreme ultraviolet lithography, EUV. And this is what Trump is playing keep away with the Chinese authorities, where there's an older technology called DUV. And he's letting, and I'm not entirely sure how they're controlling this, but he's letting, I guess through diplomatic treaties and things, he's letting ASML sell the older machines to Chinese companies and things like that, but they're playing keep away with the extreme ultraviolet machines. So there's a company in TSMC that basically has the monopoly, and they kind of a number of years ago backed this new wave of technology and have profited tremendously from it by buying and implementing these machines. And I mean, when I say a machine, we're not talking like your air fryer or your pressure cooker. We're talking like a thing the size of a double-decker bus that costs $200 million and has to operate in an absolute vacuum in order to produce these microchips, essentially. Now, I mean, this is a real technology, but we don't know the exact implications of this. TSM or ASML now has moved on to the next generation, which they call nano aperture. So, I mean, those words there, it's an even smaller laser, an even smaller beam, and they basically create it by they vaporize this little lump of tin that then creates this light particle that gets bounced around all these mirrors. There's one company called Zeiss that produces these optics essentially that reflect this thing, and they say that the accuracy, it's like being on the moon and having to pinpoint with a laser a penny kind of sitting on the Earth's surface, right? So hugely accurate. Now, Intel has seen their market share eroded by the likes of TSMC, and they're trying to jump along and kind of jump onto this new wave of microcontrollers and things like that. So they're now got a fab essentially in the US, created by ASML, that they're implementing to now produce this next generation of chips, right? So now we're potentially going to see even more powerful microchips coming out into the market. There are a lot of unknowns here. So, I mean, one of the criticisms of the current chip ecosystem, and we saw this with the pandemic, is there's huge supply chain issues, right? There's all these different providers that make one or two little parts of this whole system, and if one or two of them fall away, then suddenly we have no microchips, right? I think the hope is that this new kind of nano aperture technology is maybe going to be less complicated and result in that. But either way, we're going to see a lot more chips, or we're going to see fewer chips controlled by a few wealthier people. So that's one technology to think about. Then the other thing that was a big buzzword kind of the past year is this whole phenomenon of agentic AI, right? We're all just getting a handle on generative AI. Agentic adds a few more syllables into it. So this is really AIs using tools. And you would have seen it if you use ChatGPT. There's buttons there to get the AI agent. It could do some basic web browsing for you. Now, the last few months, we've seen OpenAI launch Atlas, which is their own agentic browser, right? So it looks like something new. It's essentially built on top of the Chromium web browser, which is an open source browser that powers Google Chrome. And, criticisms leveled against that is, search is surveillance, right? There's a whole bunch of privacy concerns with that, now amplified by generative AI, where you're essentially feeding it all your prompts, every little website you visit, and now that's all getting plugged into the model. And as I always say with generative AI, when you stare into the abyss stares back, right? It's not you just talking to the AI is talking to you. You're helping kind of build those products. Another technology that we talked about a lot today, Katrina and Nikos talked about self-driving cars. That's an example of embodied AI. We're now taking these AIs and giving them physical bodies. I'm sure you would have seen the clips on YouTube of the little humanoid robot called Neo from 1X, right? It's like a little, kind of shorter than a little human. It's got this sort of material face. It looks a bit like a walking, Amazon Echo or Alexa pod. And a lot of the criticism was leveled against that is it's walking around your house packing your dishwasher, but when it can't do something, a human operator puts on a VR headset and they're standing somewhere driving this thing, telling it what to do. So criticisms are going to have people in emerging countries operating these robots. And that's really a stopgap in my view. What they're doing is very clever. They're essentially training this robot through human experience in your home, where it's going to be walking around dealing with your children, dealing with your domestic life, and they're training it, and this is the first step in kind of consumer robotics that we're going to see emerging over the next few years. And the last one's the most science fiction of them all, but I think something we do have to think about, and I don't think any conference about AI would be complete without mentioning it, and it's a potentially exciting time to be alive, is there's a real possibility we're going to see the AI singularity in our lifetimes. And I mean, it depends on how close you think AIs are. And some people might say, you know, Dave, ChatGPT can, you know, is hallucinating case law. How is, you know, ASI just around the corner? But, you know, the reality is, so AGI is when the AI is as smart as your average human for various tasks, right? ASI, artificial superintelligence, is when the AI is smarter than the collective sum of all human intelligence, right? And there's a really interesting podcast called The Last Invention. And the reason it's called The Last Invention is either this AI is the last invention humanity ever needs to make. We end up in a techno-utopia where there's world peace, we have abundance of resources and it solves all our problems, or it wipes us out. It's worse than nukes, it creates bioweapons, who knows, right? Either way, it's the last invention. So there's two kind of camps there. There's the AI doomers, interestingly, we were talking about the Knights Templar, this auspicious place where we are. There's a biblical tale of Moloch, which those of you who are kind of in the AI space might have heard of. But Moloch was sort of this proto-religious cult that is referenced in the Bible in several points. And they were supposed to have sacrificed their children in fire in the pursuit of greater military power and success, right? And that's been used as a metaphor for how we're currently pursuing AI. We're sacrificing our children, the next generations. We're racing faster and faster to produce these things without thinking about what they might do. And that's why we see people like Geoffrey Hinton. So he's, you know, widely regarded as sort of the godfather of AI, formal kind of Google expert who's kind of turned AI doomer. And you know, he's not very positive about AI, but I think where he's seeing kind of the golden path, and it's something that resonates with me, is if we are going to kind of go the route of an AI utopia, we need to solve the alignment problem of how do we get a really smart thing to look after a bunch of really dumb things, which is what we are, right? And the only example he cites in nature is mothers look after their children, right? They have, but that's a product of, you know, human evolution and biology. There's all these hormones and chemicals making that happen. We'd need to hard code that into the AI. So it's against that scientific backdrop that I actually eventually want to push advance in the slide and talk about how do we practically govern these things? How do we manage the unmanageable? We don't know what's coming, right? And I don't have a lot of revolutionary ideas here. I think when you're faced with complex, unknowable situations, you want to go back to basics, you want to do the simple stuff. So we need to strike a balance. We want innovation and risk, right? It's tragic if AI kills us all, but it's also tragic if we continue to live in our world of poverty and inequality and injustice, things that AI could benefit. We need to find a way of doing both of those things. We need to meet supervisory and authority expectations. We've got regulators, people in different countries who are going to come and give us rules and things to follow, and that's going to make things better. Start now, right? That's the challenge of the AI is not waiting for us. I always have this phrase for companies that just because you don't believe in AI doesn't mean it doesn't believe in you, right? There's people out there using it to, process data around you, around your business, around your clients, and everything like that. And then we've got existing tools, right? In the same way, you know, Raphael talked about how Google was fined under the data protection legislation, not under the AI legislation. We have existing policies and procedures and things. We need to adapt those for the AI context. So yeah, why is governance important? Why is it now? We've talked about this a lot, accelerating. Shadow AI, this is another example of, and this is increasingly a problem in organizations, is, you know, if you're not training your employees and your staff about how to use AI, it doesn't mean they're not using it, right? It's like the phenomenon of, you know, prohibition in America in the 1920s. People wanted to drink alcohol, you couldn't stop them, right? And you'd rather have them, you know, doing it under your supervision when you know about it. You know, regulators and boards expect action, people want stuff to happen, and you know, act before the headlines and fines. And this is kind of my principal concern with the way the world's going at the moment. You know, we saw with GDPR, Europe really leading the pack and everyone else kind of following them, you know, even with the California Consumer Privacy Act. Now, Europe's led the pack with AI, and the rest of the world's looked at it and said, you know, gee, we really want to make a lot of money and, you know, beat the other guy to the AI race. We're not going to regulate at all, right? And that means something terrible is going to happen at some point, and then the regulation is going to come. And we just hope that terrible thing isn't you know, widespread loss of life or anything like that. So we've come up with a Do Now program. So this is just something at Michelson's that we kind of have that we help our clients who are looking at AI and what they want to do. Let's go through those steps, broadly speaking, and discuss some of those. So the first one is mandate and brief the board, right? You can't manage what you don't understand. And this is the challenge, and we particularly see this in South Africa, where the people who run organizations are the old folks, the incumbents, right? They're not interested in new technology necessarily, and that's dangerous, right? Because the technology is coming, you can't get away from it. You need people in charge of it. You need to adopt your own hard lines. You know, if the government, if the regulators aren't making the rules for you, you need to decide where your own limits are. And yeah, talk to people, educate them. And there's this weird situation where it's actually the younger people in organizations that are maybe going to have to come and kind of educate senior management, which is a hard pill to swallow sometimes in very hierarchical organizations. Designate the owners, so appoint yourself an AI officer or an AI governance officer. It's an interesting debate. I quite like the idea of having someone whose job it is to drive AI adoption and someone else driving AI safety. You can kind of have that push and pull and achieve that balance between the two at the end of the day. And you know, much like data protection, AI, in the same way it takes a village to raise a child, it takes a whole organization to comply with these emerging technology laws. You're going to need a committee, you're going to need a whole tribe of people looking at this issue to handle it. Yeah, define roles and handovers. Then yeah, what you can do today, start building an AI register, right? Find out what AI is out there. And I think a lot of organizations with the whole phenomenon of shadow AI, you know, people being pressured to do their jobs more quickly, people are using it all the time. You might even need to have like a moratorium on kind of prosecuting people for AI use. Say, look, we want you to get permission before you use AI in your business, but if you're using it for the next month or two, come ahead. We want to find out what you're doing. We want to regulate that. And more than that, I think the shadow AI argument, people focus a lot on the kind of the stick of it, of like, you know, it's going to compromise our business. People are leaking our information. People are, you know, giving away our competitive secrets. There's also the carrot, right? If shadow AI is happening, that's a whole bunch of institutional expertise about how your business works with AI that's getting lost if those people aren't talking about it. Most organizations will have the early adopters, the people who are driving AI use in your organization, and you want them to be teaching everybody else, not hiding that success from other people. Yeah, just triaging high-risk use cases. You know, a lot of the stuff is common sense from like the data protection world. You know, when you're dealing with, you know, large data sets, unconventional technologies, sensitive data subjects, that's the kind of high-risk data processing that you want to do your AI assessments with. Then a policy pack. This is something we've actually done a lot of work on at Michelson. So we have a free acceptable use of AI policy, and we kind of do webinars every month or so around that. And that's based on the concept that, you know, in the same way most organizations have an acceptable use of IT policy that tells you what you can do with everything from social media to using your phone at your lunch break to book your doctor's appointment, there's things that you shouldn't be doing with AI. And educating people, you know, you have your free consumer AI tools, and there's certain things you can talk about on that side, but we might have corporate tools. We might have sprung for a Copilot license, or we might have built our own internal tech stack of local LLMs that we control where the privacy concerns are mitigated, and we might have steps as to, you know, how we want to regulate those things. And then, yeah, working with your suppliers, you know, there's also this saying that I have, which is no organization is an island. You know, your AI use might be super secure, but someone else in your supply chain, someone who's providing you with critical components that form part of your services, they might not be using AI in a way that agrees with you. So you need to check those contracts and regulate that. And then, yeah, AI governance and literacy. It's encouraging to talk to some of the delegates and attendees here today, and we've met a few people who are involved in various aspects of AI literacy and stuff like that. And I think the reality is this problem, and it's sort of this bug and this feature in AI, and this is something that they go into a lot of detail in the Last Invention podcast, is there's a bit of mystery made in it, right? How did we make these models? How did we take a machine learning structure, feed it many, many gigabytes of information, and suddenly it started spitting out usable content, right? Model explainability, we don't fully understand how these things work. And we're getting tremendous results from them, but we've kind of made this thing in a semi-organic way. And we're now working together to try and understand it, unpack those elements. And, you know, we kind of want to understand the AI before it understands us, is kind of the fear at the end of the day. And there's various, one of the studies that I really enjoyed reading was Claude did a whole paper on model explainability, where they talked about when it generates an output. You know, we're so used to seeing it writing a sentence from beginning to end, it often predicts the end of the sentence before it predicts the beginning. You know, you might instruct it in English, it thinks in French, in German, in symbols, it bounces around inside the model. It doesn't operate the way we kind of understand it. So there's a lot of things we need to work together collectively to understand, and that's only going to work if we achieve literacy as a group. Then yeah, the last one's really just monitoring and keeping track of things. So these are all kind of standard things. The one I kind of want to focus on really is like adopting incidents and bias playbooks. So things will go wrong, right? You know, we've seen this happen a lot in the data protection world. Things get leaked, things get hacked. You know, from an AI perspective, the classic one in the legal world is someone submits heads of argument with a fictitious case or something like that. Now, a lot of law firms, their response to that would be, no, we're not going to use AI to draft heads of argument at all anymore. Well, the cat's kind of out of the bag, right? Clients don't want to pay for hours and hours of legal research when someone can do it with AI. So you need to develop a process that gets the best out of AI, helps you produce those heads of argument, but doesn't find, I'm seeing shaking heads over there, but a lot of people don't like the idea of that. But the thing is, if you don't do it, someone else will. So I think we need to strike a balance again at the end of the day. Yeah, I want to start this week, where to begin at all. You know, I'm a big believer in the MVP, the minimum viable product. Pick one high-risk thing, and this is kind of what you can say to your clients as well if you're a lawyer, is pick one high-risk use case where you're using AI in your organization. Focus on that. I like the idea of the simple kind of 3-question survey. So asking people, okay, for this activity, what AI tools are you using, why are you using it, and what data types are you using there, and kind of get the conversation going. And yeah, let's talk about AI before it talks about us. And yeah, those are my thoughts about that. Thanks very much.
Thanks so much, David. I think on the practical governance, it's really important, I think, for some of you to really be focused about the following, because I've just come out of advising one of our telecoms companies using big data to secure the major funding from private equity. But the GDPR, the EU Data Act compliance, was incredibly detailed. We've sailed through. But you're going to get that. Any company looking to raise serious money from a fund, looking to IPO, looking to sell, has got to be ready now, because the lawyers acting for those major companies and in relation to the IPO sign-off are going to want to make sure that there's no risk in terms of AI Act or AI regulation exposure now. So just remember that, and you've got to plan, most companies got to plan ultimately for an exit or funding. So don't think, oh, the regulators, it's only going to come forth August 2027 and the regulators won't find us. It's going to be, you know, very soon now. Your next funding round was an IPO. And also in the contracts with indemnities as well, when you enter into contracts with major providers, you're going to have AI indemnities. So please start thinking about what David just told us in terms of the governance now. It's a mistake to leave it till the regulators come on board, because you're going to get that now in the contracts. So bear that in mind as we go on to the last speaker, who's from Lexing, Canada, and he is Frédéric Letendre. And if you know a little bit about Canada and a name like Frédéric Letendre, it may be no surprise to you that he's from Montreal and Quebec. So over you to take it away and really look at predictions for the next 10 years. I mean, the next 2 years would be pretty difficult, but you've got 10 years, so take it away.
Thank you, Daniel. Thank you all, and it was a great day. Thank you for the invitation, the organization. This is my first meeting, so it was a big challenge for me to close the session with the last or almost last conference. As you know, it's pretty difficult to predict or to see in the future. I could have brought my chicken, open it, and we can have read it or read into it all together. But I prefer starting on real cold facts. So what will we do today is we'll think about the past to better understand the future. And the way I organize this presentation is through different stakeholders. The three main stakeholders are government and public authorities, corporation and private entities, and civil society. And after that, my conclusions will be mainly an editorial, considering I'm not the legislator, and each country will have its own way to do things. What have we learned? We saw a bunch of presentation or a few presentations today going back to the start or the beginning of AI. Let's go back a little bit further. Sorry. As a French speaking, I'm always mixed further and farther. Anyway, let's go back 30 years ago. When www arrived early 90s, it was a quite new thing. It was the Far West. We didn't know what it was. We could have expect that it will be very important. It will change our life forever, but I am not sure we realized in 93, 94, 95 what the impact this technology or this new way of organizing information will have on humanity, on the world. 10 years after Web 2.0 arrived with user-generated content, where each human became an editor. Each human can control almost any content. That was a huge challenge for, obviously, lawyers, but for everyone. It was another way to communicate, and it create new challenges. More recently, privacy laws or privacy was a new thing, and we found original ways to address it. So what all those steps have in common, and probably it's the same thing as AI. We learned that it's pretty long and pretty complicated to regulate new challenges or new technologies as big as those, or new steps as big as those. We understand, we learned that those solutions are automatic. You launch something on the web, bam, it's everywhere instantly. It was brand new in the 90s. Now it's common, but it's still a big challenge. We had to create extraterritorial laws, which it existed before, but any internet or digital related laws is extraterritorial or has an extraterritorial aspect of it, because contrary to any other physical products, internet or digital services and products are global. It's multi-platform. It's not just TV or newspaper or radio. It's on every platform instantly. That's a huge challenge. And I liked when one of the speakers, and excuse me if I don't remember who was it, but someone said this morning, it's not one thing, it's not one act, it's global, it's transversal. AI and all those steps were an ecosystem by itself. It has to be taught that way. It's not just like, I don't know, copyright. Copyright is one thing. You manage works. Trademarks law, you manage trademark. Here, we manage an ecosystem. It involves privacy, IP, IT, civil law, common law, contracts, whatever, it's everything. Okay, so we have to think that way. It's a 360 environment. Or like maybe a spider web. When someone moves here, you feel it here. Okay, it's the same. So we have to think differently. Tim, you said this morning, you're talking about AI, but I think we can apply it to those steps as well. Walking around in the dark, eyes closed, looking for a torch. I don't know, I've started my practice in '94 when the web started. I felt exactly that way. But we found ways with years. It took time, but we found ways. And one thing we learned as well, and I'll switch topic after. One thing we learned is that we can be very creative in those new environments. We can find peculiar solution for peculiar problems. For instance, in 1999, the Uniform Domain Name Dispute Resolution Policy was adopted. It was a pure web solution. We didn't wait about the governments. We didn't wait about UN. We didn't wait. The stakeholders decided that, okay, if we're about to create addresses, so web domain names, let's find an original way to manage this. So we will avoid some cyber squatting problems and other stealing problem. So that was a pure digital solution for a digital problem. Not as, yeah, let's say it's as original. Creative Commons. Creative Commons created a bunch of rules to manage free content on the web. And it's a pure digital solution. So I'm sure in the future, we'll find ways and we'll find solutions as creative as those two examples I gave you. Government. Obviously, please regulate faster, but as we've seen this morning, if we regulate too fast, and I loved the first example we had, I think it was Frederick who gave it, the EU AI Act was adopted in 24, but it was drafted before Gen AI existed, or it was drafted before November 22. So they acted fast, kind of, but they missed the Gen AI part. But it was fast. Other countries, as we've seen with Switzerland, for example, are waiting, okay? Maybe it's in their genes, but they're, they're waiting, okay? That's another approach. So let's make sure that we work with our governments to find the right pace. And I'm more Switzerland or UK law approach with principle instead of very precise rules, because I think with technologies which evolves as fast as AI, we need more principle than very strict rules and everything, but that's an editorial comment. We must, and that's part of the principle or a sandbox, it shall be variable, the variable geometry laws to make sure that we'll adapt. In Canada or in Quebec, years ago, a law was adopted for cybersecurity. Maybe it was like 20 years, 25 years ago, and they identified a specific method to protect information, like a key, okay? The time we adopt the law, this technology was way outdated, okay? So we need more principle than specific things, I think. And obviously be open-minded and work with the other stakeholders. But I think that part is going generally well. Private entities. I've said it, I don't know, I gave a conference to the bar on social media in 2010 about defamation and social media. It was a new thing in Quebec at the time. And I said the same thing I'm telling you today. Don't wait for government to rule. Do stuff by yourself. And David before me gave a bunch or give you a grocery list to reach that goal. Governance, internal governance, awareness, train your employees. It comes from us. Don't wait for government to do something. It will come someday, okay? But in the meantime, it's in your hands. For example, we had a client who asked us the other day, we just realized that our employees are asking questions to ChatGPT, the free version, and we realized that they are embedding into their prompt a lot of critical information, okay? No law can do anything about it. Okay, it's training, it's awareness, okay? They should have known, but it's brand new. We see with Switzerland, the villains are targeting old people like me, more than 55. It's a question of knowing, read, be critical. Look at YouTube videos if you want to learn something, whatever. Have passcode in between family members, do something, okay? Obviously, awareness agreements. I think at our level as attorneys, what we can do is help our client with obviously adapted and specific agreements. Even though the law does not exist, for instance, in Canada, we don't have such law as you have in Europe. We had a project, but the government changed, so we have to redo everything again. Not obviously, but luckily, in the last budget, there's a huge aspect for IP and AI. But it's, for the time being, it's only an idea. It's not even a law. So what should we do? We shall work with our client to make sure that the agreements are adapted to their situation. And when I talk about agreements, I'm not just talking about agreements between a client and a supplier or whatever. I'm talking about user license, everything you'll do on your website. You have to think AI now, so it's in your hands. Civil society, obviously, be aware. We need literacy, awareness. I think government and other entities should do it, but by yourself as an individual. You shall be curious. You shall be critical. We've seen that internet exists since early 19s, the way we know it today. And the frauds and the stealing and the villains, it's not a new thing. It's not a AI thing. It's an internet thing. Actually, it's a human thing, but let's put it digitally. We've got problems since we launched internet. So be aware and work with others. And as I said, within your family, it's funny because my father the other day sent me an email. He had a broken leg in Somalia, but he was sitting beside me in the living room. And he asked me for $5,000 to pay for the bill. And I asked him if it's him. He told me, no, I don't think so. Thank you, Dad. But that's one thing. My son's partner, who is now 15 16 called his grandmother the other day for $1,000 because he was stuck somewhere in Montreal. It was pure AI, and the grandmother reacted well. Oh, why are you calling me? Usually you call your mother or your father, and let's call them together. It hung up. It hung up. So you have to be quick. You have to be more aware of what's going on. And obviously, you have to, as an individual part of your society, get involved, ask questions, call your deputy, whatever, do something. Okay, that's in your end. That's your part of the deal. Okay. Yeah, okay, you ask me more, so I give the people more, okay? Okay, this is my conclusion. Everything we said today is true with our own lenses. Because if you look at the same issues through the US government lenses, or let's say the China government lenses, we will have different answers than what we discussed today. And any country will be somewhere in this constellation, okay? In Canada, for instance, we're somewhere, as usual, between US and EU. I understand that UK and Switzerland from the presentation today are somewhere in between. So what will be the law for the next decade? I don't know, but it will be certainly influenced by the lens you will use. Thank you very much.
Thank you so much, Frédéric. So now just a couple of points on logistics. We're going to have drinks now outside, so make the most of those and enjoy. And then I suggest when you finish, when you come out of the stairs, take a left. You'll see the preschool and care office, but then if you do a left and a left, you'll see the Temple Church that we've mentioned so many times today, so it's really worth it. And when you do the left and left, there's a sort of rectangular doorway, so please do that. But most importantly, I really wanted to thank the speakers today. It's been quite a journey through AI regulation across the globe. And I'll just go, I think everyone deserves a special thank you, so I'll just read it out. We started off with Frédéric Foster from Lexing, France, gave us the introduction to the AI Act. Then his colleague, Jérémy Bensoussan, on the scope and structure. Then Marc Gallardo from Spain on the risk-based approach to AI governance. And then from Lexing, Mexico, we had Enrique Ochoa on the obligations. From Finland, we had Jan Lindberg on the penalties for non-compliance. From Lexing, Italy, Raffaele Zaloni on the Italian implementation. Grazie. It's been quite a journey. And then we went to Sweden for Katarina on how the AI Act affects different sectors. Lexing, Greece, Nicholas talked to us about compliance challenges. So thank you, Nicholas. Then we had the UK team, my colleagues Jose Saris and Sylvia Eriksson on the UK approach. And then from Brazil, Flavio came over from Brazil, so thank you very much. Then we had the competition angle from my colleague Tim Karen. It's been quite a journey, as I said. And then Sebastian Fonti from Switzerland. And then, as we saw, to conclude, David from South Africa and Frederick from Canada. So thank you to all of you. Thank you for staying with us. I think there's been over 1,000 people also viewing us online, which shows the interest. And obviously, look forward to sharing a drink or two with you afterwards. Hope you found it useful, and I'll hand it over to Frederick now.
Well, thank you, Danny. And as the Executive Vice President of the network, I would like to thank Danny, to thank his team, to thank Michelle, because nothing was possible without Michelle, I think. Well, she's done a lot of work. So thank you to all of you for the organization of this conference, and see you next year in Paris. Bye-bye.